Okay, we are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are using this format, all the ordinary rules of oral argument apply as though we were conducting argument in our own courtroom, which includes that each side gets 15 minutes with no rebuttal. With that, I'm going to call the case of Commonwealth versus James Martin, case number 2019 P 1476. And Attorney Opperman, we're ready whenever you are.
Thank you. And may it please the court, Aaron Opperman on behalf of the appellant, James Martin.
And I'm sorry to interrupt you right out of the box, but Attorney Colaflores, you should put yourself on mute.
Yes, Your Honor, I had a physical mute on. I'll mute myself as well in the software.
Okay, couldn't see that. Thank you. I'm sorry, Attorney Opperman.
That's okay. There are two issues raised in the appellant's brief. This was a short bench trial, and I think the issues are somewhat straightforward. The first issue relates to the comment of defense counsel made at the very beginning of his cross-examination of the alleged victim in an indecent assault and battery case with, I think, objectively no corroborative evidence. There was a first complaint witness, however, no corroborative evidence that didn't stem from the alleged victim's statement herself. At the beginning of cross-examination, as you all know, defense counsel said, "I'm very sorry to have to cross-examine you or have to question you. I know this is very traumatic." The appellant raises that this is an ineffective assistance of counsel that communicated to the fact finder his disbelief in his client and his belief in the alleged victim's testimony. And I think the main support for that claim is that the defense presented at trial, and the only possible defense in this case was that the alleged victim was lying, either that she was lying about there being a lack of consent or lying about the events themselves. That was truly the only possible defense, and that was really, though.
I'm sorry to interrupt.
Okay.
You know, oftentimes attorneys do this to not alienate the jury. They say something like this in order not to alienate the jury right before they're going to begin vigorously cross-examining sympathetic sexual assault victim, which is what happened here, which was what we had here. I understand you would say alleged, we'll say alleged, right? But they don't want to engender through a tough cross-examination some kind of negative reaction by the jury towards the defense counsel. Why is that not how we can understand this comment here?
I do understand and agree in a general sense with Your Honor's point. I do think that there's a line to walk and a balance to be struck. In this case, I think that line was significantly crossed for a couple of reasons. One, this wasn't a jury trial. I think that there are certain considerations a trial attorney, especially a defense attorney, defending someone accused of a serious crime, particularly when a defendant is charged with a sex crime, and when someone is claiming to be the victim of a sex crime, that there are considerations to be made. However, I think it's very different in a bench trial. I don't think it's necessary in the same way. Furthermore, I think in this
counsel, it's interesting. I'm struck by the question in my mind, which way does it cut that it was a bench trial? I mean, ordinarily, we would be less concerned about this kind of extraneous comment by a trial lawyer in a bench trial because we we would consider the judge better able to eliminate the extraneous comments and get to the facts.
I agree, and I think it cuts both ways. I think in the first part of the question here, whether or not it was ineffective assistance of counsel, I think the fact that it's a bench trial means that the comment wasn't really necessary, and I think the comment itself, apologizing for having to cross-examine someone is one thing. Calling something traumatic really does speak to the allegation itself.
Attorney Opperman, could I interrupt just also and say, could that also not be a strategy for developing, I think as your brother may have argued, a rapport with the witness in order to set the witness a little bit off balance before beginning that cross-examination, which wouldn't matter if it was a bench trial or a jury trial, right? And we don't have a new motion for new trial that would lead us to.
I think it's possible that that could have been a strategy. From an appellate, from my perspective, raising this issue on appeal, I don't think it was a good strategy, and I have tried many cases as well. But my argument relative to not having filed a motion for a new trial, which this is the first time I've ever raised ineffective assistance without doing so, because I know that it is almost always necessary. I think for this particular issue, defense counsel's intent, even if he was trying to build a rapport with the witness, the words he chose, they really communicated a belief in her testimony because he used the word traumatic. If someone is lying about being the victim of a crime, and lying in this case would have been about being the victim of a sexual crime, then arguably, and the defense that was presented at trial was that she was not the victim, so did not truly go through, with respect to the defendant, anything traumatic. And so I think it's really that word in and of itself that belies the need for any explanation as to strategy, because the effect of the comment on the judge, the fact finder, would have been and was the same irrespective of the explanation of defense counsel. So that is why I don't think it's necessary to even know what the explanation is.
I see the word traumatic. I have to say that when I read the transcript, it seemed to me to refer to the process of examination, not to the crime. The comment was, and I really apologize in advance for having to do this again. And I'm assuming that this means examination, since it's cross-examination. I know it's traumatic. So why wouldn't the it refer to examination?
I do agree that the word this is referring to examination. I think that's the most reasonable interpretation of that. I don't know what the again meant. The alleged victim was never examined prior to trial, so I'm not sure what the again meant. But I don't think we can be sure the it refers to the examination. And even if we could, again, if someone is lying about being the victim of a crime, then being examined about what happened should not be traumatic. And I really think, again, it is just the specific use of that word that conjures up the image of someone being the victim of a crime.
So how is it then that this is not a classic situation of requiring that the issue be put to the trial judge in the first instance to determine what was the meaning of what the attorney said, and how did the judge interpret it? And whatever interpretation there was, what was the impact on the fact finder, which, as you said, is sort of the critical question. How do we determine those things in the first instance?
Right, and I think it's an interesting question, having a motion for a new trial raised before a judge when the question at issue is not a legal question, but a question that would really be for the fact finder. That's not normally what is raised in a motion for a new trial. Unfortunately, defendants don't get to file motions for new trials and ask the jury members or prior jury members questions. So it's a very interesting question. I would say that because this isn't a legal issue, that it wouldn't be the type of issue that would normally be raised in a motion for a new trial, to question the judge, not as the judge, but as the fact finder. And I think that the impact itself of the comments are really what's important in this issue. And I think on their face, the use of the word traumatic and expressing that
But you ask us to address that, what, as an objective matter, as opposed to I mean, ordinarily, one of the questions on a motion for new trial about something like this would be to the trial judge, did he think in the context of trial that it had an impact? Wouldn't we have to have something akin to that as a question on a motion for new trial where we have a bench trial?
I think it's possible. And again, I certainly think I could have raised this in a motion for a new trial. My position was that it was unnecessary because the comment itself on its face expressed disbelief in the client. And that's something that is certainly one way to be ineffective as counsel.
Can we switch, if it's okay with my colleagues, to the second issue, the question of the admission of the text? You argue quite forcefully in reply, look, there has to be something here that connects the text to the defendant, and there is no such evidence that connects the text to the defendant. And the prosecutor's position is, well, actually, there's a statement about it being in a parking lot, et cetera. And you say, but that's bootstrapping. You're using the defendant's own testimony to connect it. Do we have any cases that help us with that? I went back and read, Purdy and Miola, and Williams, which are sort of the trio of most important cases. And they don't really, it seems to me, get to this problem. They all seem to be working out of a construct where they need something that independently connects the communication to the defendant.
Right. I think Williams, in my view, is the closest on point, mostly because the court there finds that the text, it's clear from the message itself that the sender has knowledge about the facts of the case. And so I think that's the case that I have found most analogous to this situation, where the proposed conforming characteristics related to the allegation itself, and the court saying that that wasn't enough because, and I think the inference is because if the allegation is made up, if the event did not happen, then how do we know, it's just a bit of circular reasoning.
What about the timing?
I'm sorry?
What about the timing?
I think, I know the Commonwealth raises the timing as authentication in its brief. From what I remember, the email sent from the alleged victim's nephew, the first complaint witness, to I believe it was a detective in the state police department. The email itself had a date and time stamp that conformed to the date and time of the alleged crime, but there was no further information about the date and time stamp. There was no.
I thought that there was an indication that the email that came to the victim was at 10:33 the morning that she was in the courthouse. That's my memory.
It's the text.
I'm sorry, the text, yeah.
Yes, I think that the email had a message in a kind of a cut and paste message in the body of the email with the date and the time that the alleged crime had happened. Yes.
So can I ask a different question? what do we do with the fact that the victim testified to the contents of this text on direct without objection? And so it's in. The context of the text are in.
Right. I think
And
that-
she actually testifies it came from the defendant without objection. I mean, what do we do with that?
I do argue that this issue is fully preserved, and my support for that stems primarily from the motion in limine filed prior to trial, where defense counsel asked for the substance of the text to be excluded completely. Normally, as I acknowledged, normally that would suffice to preserve the issue, but I do understand.
What did the judge do with that motion? Was that that's a good point, counsel, and I kind of had missed it. So there's a motion in limine. Does it ask for the text to be excluded or for the contents of the text to be excluded?
My notes and my memory serves me as the contents of the text to be excluded. And I would have to go back to the record appendix.
I think it was the
transcript.
It was the document.
Motion in limine, I got it in front of me now. Motion in limine to keep out texts of defendant without proper authentication.
So it could be a little more detailed and clear. I took that as the text messages from whatever source. And there was a motion in limine filed prior to trial, and there was an objection to the document being admitted. You're certainly correct that there was no objection to her testimony regarding the text, but I do argue that that's it.
How did the judge rule on that? How did the judge rule on the motion in limine? What was the, where's that? Where can I find that? He did not rule.
He did not rule.
Okay, thank you.
Thank you.
All right, let me see if there are any other questions. All right, Attorney Coliflores.
Thank you. So I'll pick up Joseph Coliflores for the Commonwealth, Hampden District. I'll pick up right where we left off with Justice Englander's question on the motion in limine. The judge took it under advisement to see if the witnesses would provide a clear basis for authentication. So I believe he wanted to see how the testimony shaped out.
Did he say that?
No, I don't have his exact testimony in front of me, Your Honor. But that would be my belief in deferring it because of the basis.
But it might be important, counsel, because it's important to this judge, at least, that when the victim was asked about the text, there was no objection to those texts and to her statement that it came from the defendant. And so I am interested in how the motion in limine was actually addressed at trial.
Yes, Your Honor. And I do agree. It's a little bit of a convoluted review standard where we do have unobjected to text testimony from Ms. Korchesny, as well as the objected to on page 120 and 121 of volume 2 to the actual document, exhibit number 3. So there is unobjected to references to the text messages, which I believe allows for the good foundation for the authentication of the text messages later on. Ms. Korchesny.
You may be right, at least in my mind, if it were not for the motion in limine, which perhaps preserves the ability, it's an interesting question. I mean, it really is important how the judge ruled on that, because if the defense counsel felt that an objection would not be worthwhile, would be futile, based on the judge's ruling, that's one thing. If defense counsel did not have that signal and the evidence came in that it was from the defendant, perhaps that helps your authentication case. It's a tough authentication case without that testimony, isn't it, counsel?
I would have to admit and concede that this is a close authentication case.
Close. Is there anything that's close to it? Certainly not Purdy or Miola, correct?
Certainly not Purdy or Miola, but I would say that Miola does say that a confirming circumstance can be from the content of the message itself. Miola specifically went out of its way to state that even absent certain indicia that were present in Miola and
But
some that
usually
even,
they're talking about something that identifies the sender as that person, right? It's the person's name is there. The person says something, you know, it's a picture of them, like in Miola, I think, right?
that's correct, Your Honor.
But here, there's nothing that says this came from the defendant. There's no testimony that it's the defendant's phone number. The only things that you're relying on are, as Justice Wolohojian points out, the timing and the fact that it says in the parking lot, both of which tie into the victim's testimony about what happened, right? But other than tying into the victim's testimony about what happened, they don't identify the defendant.
Your Honor, I would have to agree that that is a correct summation of the record. As it is presented, that is the evidence that we have that would allow the trial judge sitting as fact finder to authenticate this. When we're looking, and I want to focus in on in the parking lot part of it, it stays between us. That is an intimate detail in that text message that shows that he is the sender. This is a message that came right after the assault. So, and there's no,
Sorry.
there's no testimony that this was a delayed text message where if we could presume that it's referencing something else that happens in some other parking lot that had to stay between some other person. This was a message that was received hot on the heels of the assault in the CVS parking lot.
I would say here, I think it just would be helpful in pages 13 through 15. I was looking for this because I remembered reading it of the trial transcript. There's a discussion of the motion in limine, which we can refer to later. But the judge clearly defers ruling, saying that it will depend on how the testimony comes out. Its admissibility will come out at trial.
Any call Flores, just to make sure that I'm correct about this, there's nothing in the transcript that indicates that Ms. Courchain had the defendant's telephone number at any point. He had hers, but nothing to indicate that she had his, correct?
I believe that is correct. Early on in the testimony, when they're describing the initial interactions between the defendant and Ms. Courchain, he already had her information and went through it to confirm that he was talking with the opposing party to the foreclosure process. I do not recall any testimony at this moment that he gave her, or the exchange was mutual between the two parties. But we do know that at minimum, he does have all of her relevant contact information.
And sorry, go ahead. No, go ahead, Justice Hen.
I was just going to ask, what's your best case on the facts that are as limited as they are in this case as far as authentication goes? What's the closest parallel that you have?
The closest factual parallel, I have to admit, I have not found a close factual parallel in my research. I would rely upon Commonwealth Miola and Commonwealth KERRY, which is cited in Miola, saying authentication can come from the document itself. We can make analogs to other cases and where there's strong evidence, but here we're due to the limited record, we are authenticating it from the testimony of Ms. Courchain, as well as from the confirming circumstances within the text message. There are no further questions.
If I understand correctly, during the motion, when the motion in limine was argued, it had already been determined that this was going to be a bench trial. And part of the proffer on the part of the Commonwealth to the judge with respect to the text message was that during their investigation, they knew that this telephone number on the text message was the defendant's because of other investigations concerning similar allegations that the Commonwealth had made. Am I correct on that?
There was a significant discussion about whether or not the judge had any prior familiarity with what's going on, and that did come up. On the record itself, from the testimony of witnesses, I do not believe there's any testimony that.
Right. So the only information came out during the motion in limine.
That's correct, Your Honor. And I believe that is part of the reason why the judge deferred, that he wanted to hear how it would actually shape out because of the knowledge base of facts at that moment. If there are no further questions, I'll move on. I'll move briefly to the ineffective assistance of counsel claim. The apology, and I really apologize in advance for having to do this again. I know it's traumatic, is a reference to having to do something again, which is the questioning and going over it. Therefore, the word traumatic applies to the having to do it again. There's no really expression of sympathy for the victim for having to be a victim of a crime, other than have to restate or re-answer any questions which she had just briefly went through. So when we're looking at this, it's a tactical decision where we must ask, was it manifestly unreasonable to do so? And I would say that it was not unreasonable to do so for reasons we've already discussed. If this is a trial by jury, it allows the jury not to have any animosity towards the attorney. And in a bench trial, and in all circumstances, it allows an attorney to build a rapport with that witness, which may be used to his benefit, to the attorney's benefit later on during a thorough cross-examination, in hopes of either getting a relaxed witness to misstate something that had been previously said. For reasons, the Commonwealth would argue that this was a manifestly reasonable decision to make this minimal apology at the very beginning, and then segue completely into it with the question, were you aware at the time of this hearing that Mr. Martin actually didn't represent the bank? So there, he is going into a cross-examination that is getting into the nitty-grittiness of counsel that is stepping in for a hearing on behalf of a bank. So for those reasons, there can be no ineffective assistance of counsel because he was acting.
You think it's a reasonable thing to start a cross-examination where you have to show that someone is lying by saying, I apologize in advance for having to do this. I know it's traumatic.
Well, I don't think that he's showing that the witness is lying. And I think that
He
would
has
be
to, doesn't he have to convince the finder of fact that the victim has made it up?
I wouldn't go as far
Or
to say
there's
that.
reasonable doubt as to whether the victim has made it up?
I wouldn't go as far as to say made it up or lying. I would say that the witness is uncredible for whatever reason, that it has fallen apart in the details where we're missing the forest for the trees or something like that. But to outright say or call a witness a liar or does not know is another tactical decision that must be made by an attorney. If an attorney
Well, I'm
calls
not saying he had to call her a liar. I'm not suggesting that at all. But at the end of the day, she just testified at length to a series of events that constitute sexual assault. If he has to introduce reasonable doubt as to whether that in fact happened, right?
I do, and this is why I think this is a tactical decision. And if we kind of read between the lines and put in some reasoning here, he's putting her at ease by saying, I apologize for having to do this. If we skip forward to the closing arguments, he's completely calling her credibility into question. Why didn't you call out to the court officers in the lobby? How far away were you from that front door where there are court officers situated? When you were in the parking lot, why did you not call out to help from passing victims? Why did you wait to disclose this to the police? Why did you wait a year? This question sets up an overall arc of completely impeaching this witness, or attempting to completely impeach this witness due to her credibility and delayed disclosure. If there are no further questions, the Commonwealth would rest on its brief.
I don't see any, so thank you. Thank you both for your arguments. It's an interesting case and we've been helped by your arguments, so the case is submitted.
Thank you.
Thank you.
Both for joining us in this format, which allows us to conduct
Connecting now. All right, we are live and recording.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this format, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Marvin E. Carr, case number 2020 P0931. Attorney Regis, we're ready whenever you are.
Good morning, Your Honors, and may it please the court. Melanie Regis for the defendant appellant, Mr. Marvin Carr. The case against Mr. Carr was a he said, she said credibility case. Both the judge and the prosecutor made several prejudicial errors that went to the heart of the case. Due to the misstatement of evidence and vouching during the opening, the erroneous introduction of other bad act evidence, and comments on the defendant not testifying in the closing argument, this court should find that Mr. Carr did not receive a fair trial because the result of his trial would have been different if those errors had not been committed during the trial. I'll begin with the comment on the defendant not testifying. In this case, on the volume record 2 and page 136, there begins the closing by the prosecutor. And in the retelling of the wife's versions of events, the prosecutor makes this statement. So she knows what happened. She was there. The police officer can only testify to what he observed on her. He wasn't there, so he can't testify to what happened during the incident. They were the only two people there, so there are no inconsistent stories. She just told you what happened. I argue, Your Honor, that given the recent case in Commonwealth versus Cruz, a Mass Appeals Court case from last year, with very similar language in the closing argument that was reversed, that this court should find that the statements made by the prosecutor here are also reversible error. In Commonwealth versus Cruz, the language in the closing argument was, it is clear that the only two people who can tell you about what happened are Jan and the defendant. And it's clear that nobody else was around to tell you that story. And the court language basically says, and it's holding, that the jury's attention was focused on the fact that although Jan and the defendant could tell the jury what happened, only one of those persons actually did so. And that was the complaining witness in the case, Jan, and she was the only one to testify. And Mr. Carr argues that a very similar argument can be made here, given the language that the prosecutor used in the closing argument, where Mr. Carr.
When we consider this argument, do we not take into account anything in the defendant's closing? So, for example, here, the defendant argued that there was, and that the jury should focus on, inconsistency between the victim's testimony and the testimony of the police officer. Why was this a comment by the prosecutor not a fair response to that argument?
Based on the language that I just read the court from the trial transcript, the prosecutor essentially asked for the jury not to consider what the officer said, in the sense that he wasn't there to actually testify to what had happened. He was not a recipient witness. And just like in the case in Commonwealth versus Cruz, when you take the police officer out because the officer is not a third-party witness, and then statements are made about those are the only two people that are there, and they were the only ones that would know what had happened during that particular incident, that goes to the comment on the defendant not testifying, and I think is a constitutional and reversible error that was made when the prosecutor made that particular statement. So, Your Honor,
you really want, I mean, if you took out the sentence, they were the only two people there, you wouldn't have an argument at all, right?
No, Your Honor, I would have an argument that this is still a comment on the defendant not testifying, because it goes further. So there are no inconsistent stories, and she just told you what happened, which is very similar to the—
But if you took out the sentence, they were the only two people there, then the reference, there are no inconsistent stories, would refer back to the police officer, which would be a direct response to the argument made by defense counsel. Really, your entire, respectfully, I think your argument depends on that sentence. They were the only two people there, which you, I think, point out is similar to what was said in Cruz. But this is getting to what Judge Wolohojian asked, I think, which is, don't we have to take into account in evaluating what's said by the prosecutor, what he's responding or she is responding to that was said by defense counsel? Because defense counsel was arguing inconsistency between the police. That was really the entire argument. The thrust of the defense counsel's argument is the statements by the police officer, the statements by the victim are inconsistent. This is responding to that. That one sentence is a little bit, it's almost cacophonous to the rest of the paragraph.
Well, Your Honor, I understand that the Commonwealth or the prosecutor can comment and make a response to what the defense attorney said in the closing argument. And that's fair that the prosecutor can do that. And I also understand the court's concern that this seems to be the only line, that they were the only two people there. But I think given the context and the words surrounding this whole during the closing argument, again, that she knows what happened and she was there, and then that she just told you what happened, I think also indicates that someone else didn't tell you what happened, and that being the defendant, and that he did not testify. So I think that
the prosecutor has to be able to say, she was there, she told you what happened. That has got to be fair comment. That is not a comment on the defendant not testifying. It's bolstering the credibility of his witness, right?
Well, again, Your Honor, I think the idea that they were the only two people there, yes, that is the crux of my argument in terms of comparison this with Cruz as well, using that word only being the comment on the defendant not testifying. But I also think that the language surrounding that, and when you take a look at, so she knows what happened, she was there, and she just told you what happened. Yes, the prosecutor, can make the comment that this is a credibility case. It's a he said, she said case. But when that other person does not testify, and there's that comment that they were the only two people there, and the defendant is not the one who has not taken the stand, has not controverted any evidence, has not contradicted anything, and has not told his side of the story, I think that's where the decision in Cruz says that the jury's attention was then focused on the fact that that the complaining witness was the only person who in fact testified.
The weird thing here is that when we look at the transcript, everything the prosecutor is saying up to the sentence that says they were the only two people there are referring, the only two people the prosecutor's been referring to have been the victim and the police officer. And so normally we would read the word they to refer to the two people immediately preceding that. That sentence, they were the only two people there, doesn't make much sense because the police officer wasn't there. But you're asking us to read this not as simply a misstatement, but as somehow directing the jury to the defendant instead.
Yes, Your Honor.
And why do you think they would do that? Everybody knows that, and if it does, what difference does it make? Because everybody knows from the facts that the defendant and the victim were the only two people there.
Well, and I think, Your Honor, that then goes to, I understand the Your Honor's point about, so the next line, so there are no inconsistent stories. It may seem revert talking about the police officer and the complaining witness, but my argument here, Your Honor, is when this is a statement, now they were the only two people there, so there are no inconsistent stories. This is really showing that the prosecutor is trying to bolster the credibility of the complaining witness by saying she's telling you what's happening, she's giving you the credible evidence, and no one else, including the defendant, has the ability to do that or to basically contradict what evidence has already been put into at trial.
So if we read this part of the closing as referring only to the police officer and the victim, then what would remain of your argument?
If I'm sorry, Your Honor, just to be perfectly clear, if only what in regards to remains with the police officer and the complaining witness.
if we read this portion of the closing argument to only be referring, the only two people that the prosecutor is referring to are the police officer and the victim, right? If that's what we read this to be, because if you take it in context, the only inconsistency people have been talking about up to now has been the inconsistency between the victim's testimony at trial and her statements to the police officer beforehand. If we read it, that this whole little portion of these few sentences of the closing argument refer only to that, to those two witnesses and to that inconsistency. Does anything remain to your argument? In other words, do we need to buy your, or do we need to adopt your reading of this portion of the closing in order for there to be a problem with the closing?
Well, Your Honor, I think then that goes back to that line, that they were the only two people there. If we're still talking about the inconsistency being between the police officer and between the complaining witnesses or the wife's statements, then this line, though, that they were the only two people there, I think goes to the crux of Mr. Carr's argument that when this comment is made, that there's no way for the jury not to then think that the only other person who was there has not testified and has not given us any type of contradiction regarding the evidence or what has been argued on that particular day. Your Honor, to move on with another of the errors that were made in the lower court, there's a failure to give the jury instruction. Now, this is a preserved error because the defense counsel did in fact file a motion requesting a jury instruction for prior inconsistent statements. And I argue that just as we've been talking about kind of this inconsistency between what the officer had testified to regarding banging or slamming the wife's head against the floor, and what the wife had then testified at trial, that there really was a difference in the testimony, and that the court, the trial judge, should have allowed.
No, the question here is not whether there's a difference between what the police officer said and what the victim said. The question is whether there's a difference between what the victim said to the police officer and what the victim said. It's a different question. And the Commonwealth takes the position there's no inconsistency. The victim's statements have been consistent all along. What do you say to that?
Well, I would actually refer to the Commonwealth's brief on page 31, where there seems to be an indication that the victim's testimony did differ throughout the trial. So in one of the paragraphs during the victim's direct examination, she testified that while on the floor, the defendant grabbed her by the back of her neck and pressed her head into the floor twice. And that comes from the trial transcript at page 99. And then in the next paragraph, during cross-examination, the victim testified that while the defendant pressed her face
That's not
into
a prior inconsistent statement. That's an argument that she made two inconsistent statements in the same testimony. For a prior inconsistent statement instruction, I think you need to show that she had made an inconsistent statement previously, i.e. to the police officer at another time.
Is the police report anywhere in the record?
Oh my.
We seem to have lost Attorney Regis.
And she's been doing so well.
Let's see. All right. I think the clerk is going to go see if she can, if the clerk can find.
He's back.
I'm sorry. I apologize, Your Honor. So I heard part of your statement there, and then it cut off. So I think the last part is that it wasn't a prior inconsistent statement.
So my point was that you are arguing inconsistencies within her trial testimony, and then Judge Wolohojian, I think, asked the pending question, which she might want to ask again.
Yes.
Yeah. Was the police report anywhere? Is the police report anywhere in our record?
No, the police report is not in the record. So the only
the basis for your argument that there were inconsistent statements, the evidentiary basis, factual basis for your statement that the that the victim made inconsistent statements. Where does that come from?
So during direct examination of the officer, the Commonwealth had asked about certain where certain marks essentially had come from, and that the officer had observed. It was then during cross-examination of the officer that in fact there were no fresh marks on her, and I think this is where the inconsistency that the trial counsel is trying to bring about, and how then the police officer is describing how her head might have been banged against the floor versus what then the complaining witness or the wife is then saying how her head was then banged against the floor, not only on direct testimony, but then on cross-examination as well. So
I take it, and this goes back to an earlier question of Judge Englander's, you're not contending that there were inconsistent statements by the victim. There's just inconsistency between the testimony of the police officer and the victim?
So yes, Your Honor, that in a sense, actually both, as I mentioned, and I think that might have been where I was slightly cut off.
Okay, if it is an inconsistent prior statement by the victim, then I would like to know where in the record we will find evidence of what she previously told the officer.
So there's evidence of what she previously told the officer, Your Honor, in the cross-examination of the officer, where the trial counsel evidence that she had stated during direct examination that she had her head that was grabbed by the back of her neck and that her head was then pressured into the floor. And those seem to be different statements about what happened to her face or her head at the time that during this particular incident. So based on that, Your Honor, again, credibility, this is a he said, she said case, is the crux of the theory of defense here. And where there is this inconsistency, then it was raised by the defense counsel and that it was preserved under the motion in limine, then the judge did create instruction. I cite Commonwealth versus Newsom in my brief.
Because your time has expired. Let me just see if there are any other questions. No, all right, thank you. And we'll hear from Attorney Herron now.
Thank you. May it please the court. My name is Donna Marie Herron, Assistant District Attorney representing the Commonwealth. I'd like to address issue 2 first and then dovetail into issue 3 because I think they're kind of related. For issue 2, the defendant's claim that there was a prior inconsistent statement is completely belied by the record. The defense counsel, which is found on page 122 and 124 of the trial transcript, was asking the judge for an instruction on prior inconsistent statements based on what he claimed was that the victim had told the police her back of her head got hit instead of the front of her head got hit. And the judge accurately pointed out to defense counsel that did not come out in testimony. And he claimed he thought he did. And then the judge said, no, that didn't come out in testimony. That may have been what she said in the police report, but that did not come out in testimony. And he was accurate that both the officer
Is there an inconsistency between her testimony that her face was pressed into the floor and the testimony that her head was slammed into the floor?
I believe she was just describing it and using different terms, Your Honor, but as you pointed out, that was within her testimony, not as a prior inconsistent statement.
But if it's within her testimony, can you still get an instruction about prior inconsistent statements?
I do not believe you can, Your Honor, because I believe by definition, it has to be, if I could look at my law, prior, it was either one who says it at a different time, different from the testimony currently, and I'm citing Perez for that fact and Ortiz. So I think it has to be not during the testimony itself, but at a prior time that you said something different from what you're currently saying at trial. And again, I don't see it as inconsistencies either, because I think she was just using different terms to explain the action of what was occurring. I would then, so the judge was well warranted in not giving an instruction when there was no evidence presented, as he pointed out to defense counsel, that there was inconsistent statements, which is regarding whether it was the back of her head, which is what he was trying to get out, or the front of her head. Now, when going to the prosecutor's closing argument, it was clear, and I think any reasonable jury would have understood what her closing argument was in fair response to the defendant's argument, because the defense counsel in his argument said she told the police something different, which was not accurate. That did not come into evidence. So I think she was well warranted, the prosecutor, in her argument saying that there was no inconsistent statements, and I don't think a reasonable juror would have understood she was commenting on the defendant's silence, but rather she was responding to the defense counsel statement and trying to explain that there was no inconsistent statements. And even if there was a potential for error, there was no objection, so under substantial risk of a miscarriage of justice, and any potential error, which I don't think there is, was eliminated by the judge's forceful instructions that the defendant has no burden of proof, the defendant does not have to testify, the burden's always on the Commonwealth. But again, Your Honor, I think it was a fair response to defense counsel's whole closing that there was inconsistencies in the victim's statement to the police officer versus her testimony at trial. So I think the prosecutor's closing argument when read in context was a clear response to that, and I don't think any reasonable juror would have understood as commenting on the defendant's silence, but rather commenting that there was no inconsistencies in the testimony.
What about the prior bad act statement? I believe it was from a prior attack.
Yes, and the trial judge here properly admitted it as the motion to eliminate argument back and forth as the victim's reason as to why she delayed in reporting it to the police.
No, I'm talking about, no. There's a question, so on direct examination, it's brought out by the Commonwealth that she has bruises.
Yes, the cross-examination, I'm sorry.
And so the defense counsel has to address that and gingerly comes up to that. In your report, you indicated that these bruises were old bruises, yes or no? Yes. And then the next question gets an answer that says it was from a prior attack. That should have been struck as non-responsive, shouldn't it?
I don't believe so, Your Honor, because the whole question was, and
I'll give you the question. I'll give you the question.
Okay, thank you, Your Honor.
And you don't specifically mention when the old bruises were from, yes or no? And that gets an answer. I believe the injuries were from a prior attack, which the motion to eliminate had addressed.
I don't agree with that,
Police
Your Honor.
officer should not have said and should have been struck by the judge. Yes or no?
No, I believe that.
Sorry to parrot.
That's okay, Your Honor. Well, as I argued in my brief, I think it was a response to defense counsel's questioning. If any error, he invited the error, and I would suggest any.
No, he didn't invite the error. He asked when, and he got an answer about why or how. He did not invite that, and it should have been stricken.
I respectfully disagree, Your Honor, and I would suggest even
and isn't the judge, and let me just ask one more question on that. Isn't the judge just wrong when the judge says, because it was on your cross, I can't correct it? I mean, he has a right to cross-examine on this issue. In fact, the Commonwealth brought it out. He had to cross-examine on the issue. And if during his cross-examination, the prosecution's witness strays beyond the question, then of course the judge has to strike that.
Respectively, I think he answered the defense counsel's question. We're going to disagree in that. So even if I view it in your terms, Your Honor, or if that's how it was, I would suggest there clearly was no prejudice where the officer, during further cross-examination of the officer testified, never said that the old bruises were caused by the defendant, never said it was a prior attack by the defendant. Indeed, got him to say that the victim never said that the defendant struck her face. It was never mentioned in the prosecutor's closing, and the defense counsel was able to utilize it actually in his closing argument. For all those reasons, I would suggest any error in the question didn't prejudice the defendant.
Okay.
If there are no further questions, the Commonwealth will rest on its brief.
Let me check. I don't see. Thank you both for your arguments. This is an interesting case. We were helped by your arguments, which were very well presented on both sides. We thank
All right, we are live and recording.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. With me this morning are Justices Englander and Hand, and my name is Gabrielle Wolohojian. Although we are sitting in this format, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Richard F. Schism, 2020 P0195. Attorney Suchecki, we're ready whenever you are.
Good morning, Your Honors. I represent Richard Schism in this matter. In this particular case, there were actually two victims. There's actually two different events. There's the event where Miss Donovan's money was stolen from her from their law office. And then there was Richard Schism, who received the proceeds from that theft into his account. I think with the Commonwealth, and Mr. Schism was found guilty of conspiracy. And the conspiracy requires a combination of two or more involved in concerted action to accomplish some criminal unlawful purpose. And the Commonwealth has to prove my client's intent. Nowhere in the case is there any proof of intent. What the Commonwealth possibly proved was that my client was gullible. They might have proved that he was not savvy. But if you look through—
If they didn't prove intent, they surely proved he was gullible.
Yes, Your Honor. And I think that one thing for sure, the Commonwealth's own witnesses show throughout. Detective DeSalvatore came out to Socrates, New York, and interviewed him. And on 3 different occasions during the interview, he says that he was a pawn in this matter.
So that's what he says.
Right.
Okay.
That's the investigator.
And yeah, that's what he says. And it's understandable what the defense strategy was, given the way Mr. Schism behaved throughout the process. But the prosecutor plays the entire interview of your client. So the jury has a chance to listen to him for 45 minutes or so, right?
Correct.
And then the prosecutor argues, hey, it doesn't make sense. None of this makes sense. It doesn't make sense that he was going to get a $12 million inheritance. It doesn't make sense that he said this was a loan. And goes through a number of things which may be fair inferences from your client's own statements that he's making up a story. Is that enough? Is that enough for a jury to infer that he knowingly was receiving either stolen property or something that was related to criminal activity?
I would say not, Your Honor. And I base that on the fact that Mr. Schism, they used his prior bad acts as well. There were 3 instances in total, and 2 came in. In each instance, my client had a voluminous amount of paperwork and in proof of his contact with this. He thought there was a lawyer in South Carolina. He had the paperwork. If you read and go through that transcript, he literally, every time Mr. Detective DeSalvatore brings up a point, he has the paperwork, he has the email, and he's very concerned, my client is, that he has a paper trail because he takes responsibility as a custodial account. And even when, at one point, when the detective tells him that he was being set up, he said, "Who's leading you? I'm kind of believe, Richard, that you are a pawn in this." And he said he doesn't gravitate to it and say, "Yeah." He says, "I say possible, unbelievable, but possible." And then Detective tells us, "I'll explain it to you." And instead of gravitating towards that, like as an excuse, as a criminal would, he says, he pushes back and says he's a very, very experienced person. He has the illusion, perhaps, that he's an asset manager. And it seems to me that if you read through it, he doesn't ever once lie. Not once is there any concealment. He is forthcoming every step of the way. But the Commonwealth never once showed any connection to Massachusetts. Zero connection. They show no connection between the person who drafted an email and got Mrs. Donovan's money.
Surely they do show connection to Massachusetts. $343,000 wound up in his account.
Except for the
Well, except
like I
for
said,
the most important evidence in the case.
Except that's it, though. I mean, all they have is that.
What does that mean? one can, so what?
Well, because it doesn't prove intent. They
Why? I don't understand it. If the money came from New York or Nevada or Massachusetts, why would that affect? Why would that affect intent?
I'll back away from that point and go on to the fact that the Commonwealth didn't prove.
Could I ask another question, Mr.
Sure.
Jackie, about what you're talking about here? Why did the jury have to view your client's willingness to talk with the investigator as proof of his innocence or gullibility? Why could they not look at the fact that by the time the interview was given, if I remember correctly, there had already been 2 other instances in which some different people had advised your client that his conduct was approaching or was fraudulent, including an instance that was overlapping in time with the opening of these accounts at Key Bank, the 1226, and I'm forgetting the number of the second one. Why couldn't the jury infer from that your client was saying one thing and doing something entirely different?
Because in order to get to his intent to be part of this conspiracy, you have to pile inference upon inference. And the bad acts are informative, but at the same time, they also instruct and show that the investigators who did that before also said that it was highly cooperative. In fact, one said that the IRS agent said, and this is in the Commonwealth's brief, it says the agent Lynch testified that after this conversation, the defendant occasionally contacted him and asked him for advice or feedback. So he clearly fashions himself as an asset manager, and he's asking an IRS agent for help in trying to discern whether he's doing something wrong again. And then even with the bank investigator, Daniel Magaro, I'm not sure the pronunciation, but she says that she said Mr. Schism would contact me from time to time. There were times where Mr. Schism would be approached by another client and had asked for some feedback from me on like what to do in a particular situation if you'd received money.
Why isn't it that the jury could interpret those as, this guy is trying to consult with people who might have more knowledge in order to figure out how to cover his tracks credibly in the future?
I think you can obviously make that inference, but I think that the amount of I'm sorry.
Excuse me. If you can, then why isn't it on appellate review when we are to view the facts under the Lattimore standard, we do not assume that the jury did so?
Well, because you can't pile inference upon inference to prove an element. And there's no proof here of any intent by Mr. Schism, except for the fact that the money's in his account.
Because I in my reading of the facts, there is actually evidence. For example, I think what you're talking about is direct evidence as opposed to circumstantial evidence, right? Are you arguing that there's no circumstantial evidence of mens rea?
I think that in order to get to the only evidence is the money. I mean, everything else is not. I think that.
Excuse me. He opened an account to receive the money.
Correct, but that was before. That was actually 2 weeks before this event.
Right.
So that he had no idea.
That would seem to buttress the notion of mens rea, because that would seem to support the inference that there was planning ahead of time.
Well, actually,
excuse me. And then he opens an account. He knows he's going to receive money into the account. He knows the amount of the money he's going to receive. He has a plan with one or more people as to where the money is then going to be distributed and in what amounts, apparently. He executes those. Some of those destinations for the funds are new accounts that he creates under his own control. Some are not. Some are, one, right, went offshore. Why are not all those things evidence of mens rea?
Because, Your Honor, I think there's no connection between the actual event. He opened up his Stonington account years before. In fact, the investigator, Robert DeSalvatore, said, what's going to help you is that you were contacted way before the $343,000. He thought he was going to get $500,000 from an inheritance in the stories in the interview. But what the investigator said is really what happened here from my reading of the facts. The detective said, you're like a sleeper. They make you an agent They make you sleep for a while and they wake you up and get you that money. This is what happened here with you. I think you were an unwilling pawn. And like I said, it may have proved that he's gullible. It may have proved that he's not savvy, but he had documents in backup for all the identifications. And you also have to keep it in context of where this man lives. He doesn't live in any kind of lush setting. He does manage several accounts. It's not just one. When he does the interview with the detective, he goes through receipts and he says, no, talks about different transactions, and they're referencing other transactions that he's doing.
Can I ask a technical question about what has to be proved by the Commonwealth? So the charge is conspiracy, and it has to, and it's conspiracy to commit, I'm going to say, either receipt of stolen property or money laundering, which I understand to be receiving something that's a fruit of a criminal act. Both of those require knowledge that the property is stolen or knowledge that it's a fruit of a criminal act. You're talking about mens rea. Where does that come in? Are we talking, in other words, what are the actual elements that the Commonwealth had to prove, and where does mens rea fit?
Well, I may be using it inappropriately. It is knowledge. He has to know that there's a crime. He has to know and conspire with somebody to do and be part of these. Some concerted action to accomplish some criminal unlawful purpose. He didn't prove intent. There's no proof of intent anywhere. The Commonwealth.
But that sounds different than the knowledge of the underlying bases of the conspiracy, if you will. Is there a separate mens rea for conspiracy? In other words, in order to be guilty of conspiracy, you have to have an intent to conspire. And then separately, you need to show knowledge on one of those two branches?
I'm not sure, Your Honor, but I know if I look at like Commonwealth v. Seoul, the gravamen of conspiracy is the unlawful agreement. And there's no proof of an unlawful agreement with anybody. In fact, Mr. Schism.
Oh, no, there are all kinds of agreements here that were proved. There's an agreement that he's going to receive money and he's going to put it out in a certain way. So I think, again, precision is more helpful here.
Except for the fact that
it has to be an agreement. I think it has to be an agreement to commit one of the two underlying criminal acts.
I think at the outset, he has to prove that he knows that there's a crime going to be committed, and that he's somehow a part of that crime, and that is that the fruits of that crime are going to land up in his account. There's no proof of that at all. There's no proof with anything. They have nobody else but Mr. Schism having received that money. And nowhere in any of the investigation is there someone saying that Mr. Schism lied, Mr. Schism concealed, he was duped by anything. The only thing they say, and their own investigators say, that he's a pawn. 3 times Mr. Detective Del Sori says. Daniel Morgower said, did you inform him that in your view he was being scammed? Yes, I did. What they proved that Mr. Schism was not a capable or competent asset manager, perhaps, but they didn't prove that he was part of a conspiracy to commit a crime against Ms. Donovan.
I'm sorry to interrupt you, but with respect to the monies coming in, couldn't the jury infer from the fact that, at least as far as I read your client's explanation of the funds, that he explains that the funds are part of a loan to him in order to cover costs for a $12 million inheritance, which is to receive from someone in exchange, whom he does not know, in exchange for a service which he can't identify. And then once it comes in, he describes alternately the funds as being fiduciary isn't the correct word, but funds that he needs to treat as though they don't belong to him. And then he disperses those funds, which he's claimed are a loan to him, to a variety of other people on the instruction of a third party, as well as potentially keeping certain transactions. Couldn't the jury interpret from that your client's explanation was not on the up and up, and that he was desperately trying to gin up, inartfully perhaps, some explanation for money that he knew was coming from an illicit source?
I would think that there were too many inferences being piled on here. I think that if you look at the interview with Detective De Salvatore, if there was a question regarding anything in this transaction, Mr. Schism had a document. He was able to prove, I mean, it may be inartful. He may not have realized what he was doing, but at the same time, he had proof of everything that no one said that he concealed anything.
Even so, then isn't that perhaps more proof of the conspiracy, that he had papered or tried to paper an explanation in advance?
Oh, I would disagree, Your
Or
Honor.
not?
Even if there were 3 different investigations with Mr. Schism, not one of them said that he was uncooperative. Not one of them said that he tried to conceal something. He didn't try to hide his identity. This company or I mean, his company was formed years ago. He'd done it for years. He traveled around the world and was familiar with foreign banks. But what they didn't prove was his intent to be part of a criminal enterprise. And in this case, Mr. Schism, like I said, he was unsavvy. But they didn't prove that he had anything to do with this conspiracy to steal Ms. Donovan's money. So with that being said, Your Honor, thank you, and I rest on my brief.
Let me see if there's any other questions. No, all right, thank you. Attorney Walsh.
You're
You're still
muted.
muted, I think.
Sorry. Good morning. My name is Emily Walsh. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. There was ample evidence for the jury to conclude that the defendant conspired to commit the crimes of money laundering and receiving stolen property. The defendant's claim that he lacked criminal intent, essentially that he didn't understand he was committing a crime, is meritless, and there was ample evidence for a jury to find intent. In 2014, between $150,000 and $200,000 was deposited in the defendant's account as part of a fraudulent tax scheme. In 2014, Agent David Lynch from the IRS met with the defendant at his house. The defendant claimed he had a client with a government contract and needed the defendant's assistance in getting paid. Back in 2014.
Can I interrupt? I'm sorry. What are the elements of this crime, and where does mens rea fit in?
Well, there are 2 crimes two object crimes. He was convicted of conspiracy through both object crimes, money laundering and receiving stolen property. So with to money laundering, he would have to have the knowledge element, knowingly engaging in a transaction from criminal activity to facilitate a criminal action for the money laundering, be it concealment in this case, although we didn't need to go into that level of detail, and then receiving stolen property knowingly.
There's no separate mens rea requirement for conspiracy. You're saying
No.
that as you understand the defendant's argument, it is a challenge to the knowledge elements of each of the underlying objects of the conspiracy.
That was my interpretation of his argument. I think he also is arguing that he didn't enter into an agreement, perhaps, which is certainly contrary to the evidence and the ample evidence for the jury to find an agreement. But the way that
did the Commonwealth have to prove that the object? Did they have to prove that not only that it was an agreement, but that it was an agreement to commit a crime?
Yes.
Okay.
The conspiracy is the agreement. The jury instruction is on, as the jury was instructed on page 77 of the 12th. The jury was instructed that the Commonwealth must prove an agreement to do something criminal or unlawful. So here, the criminal or unlawful activities were the 2 crimes of money laundering and receiving stolen property. Again, he claimed in 2014 he didn't commit a crime to Agent Lynch. And then in 2015, a wire transfer was made to his account of $112,000, which was blocked. The representative from TD Bank testified at trial and talked to the defendant in 2015. And the defendant then said he expected a transfer from a Nigerian attorney. The TD Bank representative informed him that it was blocked, and told the defendant that the money was not from whomever he believed it. Then in 2016, 1 month before the fraudulent transfer in this case, he was brought in to testify before a federal grand jury and advised that what he was doing was money laundering. That was 1 month before the fraudulent transaction in this case. And he was told that a good rule of thumb would be not to accept any money from a person you don't meet in person. Despite this, 1 month later, he accepts $343,000 from a person he has never met and dispersed it. Viewing the evidence in the light most favorable to the Commonwealth, there was ample evidence to find criminal intent in this case.
Did the Commonwealth prove, in your view, that he received any money as a result of what happened here?
Well, receiving it into his account, I think.
No, I'm sorry. I misspoke. Did the Commonwealth prove that he personally wound up with any of the funds? In other words, that he received a payment himself for what he did, which was basically set up an account, receive money, and send money out?
So that was part of the Commonwealth's case at trial. In the interview, the defendant claims he didn't keep a penny of the first deposit, the $343. He claims that he didn't keep a penny of it. The way the Commonwealth tried the case suggested a profit motive and that he did keep money. If you track the transactions, which was one of the Commonwealth's exhibits and was done through the testimony of Sean Ball with charts and explanations, if you chart the money and do the math, it appears as though money remained in the Stonington Point account after the transactions. But the other thing is that—
How much?
In the ballpark of $25,000, I think. But the other issue is that he made several cash withdrawals. He made, when the money went first to account, it came into 1225, a large
He takes 300 of it and he sends it over to another account right away, right?
Yes, but then a few days later, he sends much of it back. So we start with 1225, and then $300,000 goes into 1226. So that keeps $34,000 in the original account. And then $250,000 goes to Turkey, to a JP Morgan account. So then, and a $10,000 cash withdrawal. And again, we don't know where those 10,000 cash withdrawals, anything that ends up as a cash withdrawal, it's not clear where it goes.
So he takes 10,000, that may just be a complete answer to my question. He takes $10,000 out early on, we don't know where it went.
Correct. And more than that later. There are several large cash withdrawals that would be ample evidence for the jury to conclude that he kept that money and that was his motive in this, to be involved in this. Are there any further questions from the panel?
I have a question, but I don't know that it's within the scope of record.
I can try.
Were there other prosecutions as a result of this event?
I don't know that there were other prosecutions as a result of this event. I don't think they ever figured out who the email sender was. The emails came back when we tracked the IP addresses to a city in India. So it would
seem to me, just to make an observation for the prosecutor's office, that someone knew that there were $343,000 sitting in Mrs. Donovan's account, and that was probably not anyone who was in India. And I'm a little bit disappointed no one figured out who that was. Anyway, that's just an observation.
Thank you. If there are no further questions, I'll rest on my brief.
Let me just check. Seeing none. Thank you both for your arguments. It's a very interesting case. We've been helped by your arguments.
All right, we are live and recording.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. With me are Justices Englander and Justice Hand, and my name is Gabrielle Wolohojian. Although we are conducting argument in this format, all the ordinary rules of argument apply, including that each side receives 15 minutes to argue with no rebuttal. With that, I'm going to call the case of KERRY Cohan versus John Whalen, case number 2020P0123. I would remind everyone that the case is partially impounded. And Attorney Harrington, we are ready whenever you are.
Morning, Your Honors. Mary Harrington representing the appellant KERRY Cohan. So the issue before the court here is whether 60A was the appropriate method to change the judgment in this case, which is what the judge did. And if we start with the Gagnon analysis and what was the judge's intent at the time, we know from her judgment that she intended to apply the terms of the party separation agreement. And when she was doing her decision, she read the agreement and made her interpretation of that agreement at the time she entered the judgment. And she applied her interpretation of that agreement to the numbers and came up with her judgment in the case. And we know that because she tells us that at the hearing on the contempts. And that's a benefit, I think, and that this court has, and different from what often happens in these cases. But
do you concede, counsel, that this was a correction under 60A?
I'm sorry, Judge?
Do you concede that this was a correction under 60A?
I agree that's how she tried to do it, yes. The judge applied in making this amended judgment.
Because she didn't say that. She didn't use 60A. 60A, I didn't see 60A anywhere in anything she said.
I don't think there was any other rule available to her to enter an amended judgment.
What about 60B6?
No motion was brought.
Is there case law that says unequivocally that if no motion is filed, then you can't use 60B?
I can't say that I can answer that, but I believe that 60B, there has to be a motion.
Well, that's the language, you're right. That's the language of the rule. Upon motion is the first two words of the rule. But the reason I'm asking the question, obviously, is to try to figure out what happened here. And you've addressed it as a 60A issue, and I certainly understand why, but I thought it was worth asking because of the next question, which is your client is looking for a windfall. Do you agree with that?
No.
Why not?
Let me strike that. So there's two things. So I want to make sure this court understands that my client paid him the full amount that he was due. So there was a second contempt that he had filed, Mr. Whalen had filed. I did not provide that judgment because I didn't think it relevant. But counsel in her brief twice talks about the quote self-help and that my client hadn't fully paid him what he was owed. She has since done that. Right after this judgment came out, she reimbursed him. So right now, if you're on.
But isn't she looking for a windfall in this sense? She wants to get $97,000 for 2017. And in fact, if you correctly read the agreement, she should get 90,000 and something.
Well, I understand, Your Honor, but that often happens in cases. And unless somebody appeals or properly brings that issue before the court in a timely fashion, that often happens. We have mistakes made. We have the mistake made in Gagnon itself. There was a mistake and it couldn't be changed because nobody had filed a timely appeal or a timely 59 motion. Similarly in Lopes, there was a mistake made, but it couldn't be corrected the way the judge tried to correct it. And that's what we have here. She had made a substantive legal decision. It might have been wrong, and you might have been able to correct it if somebody had properly brought it.
Do you concede that it's wrong? That if that her application, that you concede the $97,000 is incorrect as a legal matter?
As a legal matter, had an appeal properly been brought or had a 59E motion?
I accept your amendment to my question. What's the answer?
Oh, I thought I did. Yeah. Yes. Okay. I think so the court understands. None of us knew how she had come up with that number. Mr. Whalen, even in the colloquy before her, says it's so ambiguous. The only way any of us found out how she got to that number was when she explained it to us during that court hearing. And that's what I think is so important. She said, I read the agreement. This is how I interpreted it.
But statements by a judge during a hearing, we usually don't hold to be evidence of the rationale for the judge's decision. And the reason for that is, as you're going to observe during this hearing, at least with respect to me, we say all kinds of things in hearings, trying to test what the right answer is. And that is not the record of our decision, is it?
Well, I think in this case, it's relevant. I think it's not different from cases where you've remanded and asked the judge for what they did. And this judge told us in this hearing what she did. And what she tells us is she made a legal decision, and she deliberately made that legal decision. She went back after this hearing. She must have reread the agreement and decided she had made a mistake. And you could have corrected it had somebody appealed it, or she could have corrected it if somebody had timely brought it to her. But that's not what happened. And it's not what happens in a lot of the cases that have been cited, such as Lopes and Gagnon. And judges—
But if there's a 60B6 at any time upon motion, then I don't know the answer to this question, but potentially 60B6 is available. And can the colloquy at the November hearing be construed as a motion by the husband for her to make a correction?
I don't think so, Judge. He didn't file anything. He provided a copy of an answer, which I put in the appendix, but it's not—
So that's an argument that it has to be a written motion.
Right, and I think that it does.
Okay.
And again, we were so far beyond the date of the judgment at the time the hearing was held. I think we were
12 months or 13 months?
right. Something like
More than a year, but not much more than a year.
right.
Am I right?
I think that's correct, Judge.
The amended judgment that's the subject of this appeal, procedurally, it came about as a result of a complaint for contempt.
There were actually cross complaints for contempt, but yes.
Okay. So it was a judgment that was entered on cross complaints.
There are two separate judgments. There's another judgment of contempt in Mr. Whalen's case that does not find my client in contempt.
Right.
And specifically that she reasonably believed he owed her the $45.82 as of August. The court had previously allowed for reconciliation offsets when each of the parties owed the other. Since a month had passed without payment by father, and since her complaint had been filed and served, the mother is not adjudged in contempt for offsetting the amount she owed the father with the amount she owed.
What you're raising on appeal is the other judgment that had to do with his motion for contempt. Is that correct? Complaint for contempt? Your complaint contempt?
My complaint for contempt.
Okay.
Yes.
So once you file a complaint for contempt, why is the calculation of the amount not validly part of the consideration of that complaint? Because if there is a genuine, let's say, belief/basis, and I understand it hasn't been appealed, for thinking that the amount is the subject of a mathematical error or an error, why isn't that part of a defense to that complaint that the judge can consider when the issue of contempt is brought to her?
So she might have been able to consider it, but she wouldn't be able to change the underlying judgment, because a complaint for contempt has to be a clear and unequivocal order or judgment of the court. And there's no question, it was clear and unequivocal. He owed her $62.12 as of September.
It's not clear because you can't figure out its basis.
But the judgment itself is clear. The judgment is $62.12, offset by a number that both parties agreed to. So that was clear.
The natural conclusion from your argument that someone must be held in contempt for failing to pay an amount that's a product of mathematical error?
No, my argument is if a judgment has not been appealed, overturned, or properly changed, it is the judgment of that court which must be complied with. Now, a contempt there are other issues in a contempt. Is there an ability to pay, for example? So that gets into other.
I didn't read your brief as suggesting, and maybe you can clarify this for me. The part of your brief that addresses contempt, I read to be, if I win on my argument, if I, counsel Harrington, win on the argument that the $6,000 is still owed, then he should be held in contempt. I did not read your brief to say whether I am right about it or not, he's in contempt because he had a clear and unequivocal command.
No, I have to prevail in this case in order for the contempt. Yeah,
Thank you.
There's no question about that. And it's not 6212, it's reduced down to, I think the number's 4582 or 40 something. Yeah. And so I think what you have here that's different from most of your cases is the judge telling you, I made a conscious legal decision. And yes, that could have been changed, but not by her on a 60A. And 60A was the only method she could have done given the timing and what she had before her. And again, I refer you to the Lopes case. The judge in that case clearly intended to comply with the statute calculating interest and when and how it should be calculated and by whom, but he didn't. He did it wrong. But it couldn't be fixed because it was too late in the game for the court to fix it, for him to fix it, and nobody had filed an appeal or brought a 59E or B motion or another timely motion.
If we were to agree with you that procedurally this was not properly before the court at that time, why would the relief not be to remand it for someone to file a Rule 60B6 motion?
Because they already had those opportunities. I mean, all of the 60A cases that I cite that don't permit it, that's not the relief. People have appropriate avenues of relief and they can take those avenues of relief.
We're talking about right now. We're talking about because, we're not usually in the business of affirming errors. So if we see that the judge thinks that there's a mathematical error, the judgment did not correctly reflect what she intended, then why wouldn't we? Do you have a case that says we would not remand to permit the parties to bring this properly before her through a 60B6?
Well, I'm not sure 60B6 is proper because I just am not that familiar with the details of it, but there are many times where judges make errors. As most of the 60A cases, a judge made an error. But it couldn't be in Gagnon. It was an error, but it couldn't be fixed. I know, for example, in the IRF case, there was a remand, but in that case, it was one, an appeal, and two, you didn't have the benefit of the judge having said to you, I considered this, and this was my judicial determination at the time, that this was how I should interpret this contract. And I just think that makes this different from many cases that come before this court.
Do you have anything, any legal authority for the proposition that a judge does not retain inherent authority to correct her own errors?
Well, she can correct her errors if it's done under a proper method of doing so.
I'm talking about inherent authority. Not upon a motion, but inherent authority to correct her own errors.
She can if it's a 60, if it falls under the 60A.
What case do you have that says a judge's inherent authority is limited by 60A?
I think that's why we have the rules. I think that's what Gagnon tells us.
I'm not, Gagnon will tell us that a judge's inherent authority is limited by Rule 60A.
I guess I would say, yeah, the cases that talk about the rules and what's available to a judge.
All right, I think we have your argument. Let me see if there are any other questions.
Thank you.
No, okay, thank you. Attorney Cahill.
Thank you, Your Honors. May it please the court. Heather Cahill, representing the appellee husband, John Whalen. As your justices have realized, this is a discrete issue here, and whether or not the trial judge properly amended the judgment of modification pursuant to Rule 60A. It is husband's position that yes, the trial judge did properly exercise her discretion to correct a clerical mistake in the modification judgment, and that the husband was not in contempt prior to such modification. We're asking the court to affirm.
You agree that this was done pursuant to Rule 60A?
I believe it was, Your Honor, and I'd like to talk about the abuse of discretion. I think that this particular case that I found is not cited in my brief, Your Honor, but I think that it's instructive to the court, which is the Morris v. Morris decision. And it's 70 Mass Appeals Court 1110, issued on 2007. It's an unpublished decision. And the panel was Judge Duffley, Judge Graham, and Judge Katzman. And in that case, Your Honor, a lot of these cases have to do with a motion under 60A and the abuse of discretion standard to apply to such a motion. And in the Morris case, the procedure is very similar to the procedure here, where it was an underlying divorce judgment on a contempt trial. And then during that contempt trial, the trial judge realized that she had made a mistake, or he had made a mistake in the underlying divorce judgment, and on its own initiative, amended the underlying divorce judgment and also determined that the defendant was not guilty of contempt. And so I think that case is important for this court to consider when you're analyzing the power.
We'll have to take a look at it, but the question is what the error was. I mean, if the error is truly a clerical error, then yeah, 60A applies. But the problem is this substantive versus clerical? Honestly, I've been struggling with this. There are very good reasons for saying that a judgment should be a judgment, and that you should try to amend that within 10 days or appeal it. And if you don't, that's the judgment. And one of them is, and it's been alluded to maybe in the cases a little bit, that someone may be very comfortable with the judgment as it's in its erroneous state, but if it were fixed, they'd take an appeal. The other side would take an appeal. And that's why, we have to be careful about sort of running around and willy-nilly amending judgments, because we wind up unraveling things that may have arms and legs to them.
Justice England, I point you to the DeLuca decision, which was cited in my brief, and that was an amended judgment after 1 year. And the court recognized it, and it also recognized its inherent power that it could not expand an appeal, the appeal period, because in essence, the party that lost was in essence, the loser from the amendment, complained that they were unable to take an appeal from that judgment because of the expiration of the appellate period. And the appeals court said, pretty much, it's an amendment. It was a clerical error, and I have the power under 68 to amend it.
They said it was a clerical error, and my words to the effect of, and you should have known. And you should have known it was a mistake, right? I remember reading the case, but that's not a terrific principle because we're not going to hold a hearing to figure out whether they should have known or not, or whether, your client should have known or not.
Well, I think when the money was due, they were having, the record shows that they were having conversations, and the husband brought the error to the wife's attention, she filed a complaint for contempt, and he thought, as the record shows, that they were going to handle it in exactly the same way that it was that the prior clerical error was handled, and that they'd go before the same judge who issued the judgment, and he discussed the clerical error, and it would be fixed. And in fact,
where is that? You say that's as the record shows. Where is that in the record? Is this correspondence between the two of them?
No, Your Honor. It was at Record Appendix 130, lines 4 to 5, where the husband says during the hearing, to me, it is the exact same situation, Your Honor. I do not see a difference.
Oh, okay, but that's a little different than saying he'd actually communicated with the wife and that she had agreed.
No, she didn't agree, Your Honor. I believe that there is communication. The record does show. If you give me a second, I can find it. You want me to find this
No,
specific?
that's all right. I did read that passage. I understand now.
But I think that what's important here is when you look at the trial judge, who's a really great trial judge. When you look at her discussions during the hearing, she says, "I'll consider this issue." She says it several times. She admits that she has the power to correct a clerical error, but if it's an interpretation issue, she did not. And she says that repeatedly. And then she says, "I'll take the matter under advisement." And then in her order to amend, she recognizes that she did make that it was a clerical error. It was a mistake on their end.
She doesn't use the word clerical.
She doesn't use the word clerical, but she does recognize that there
She
was
says
a mathematical error.
incorrectly applied. That's what she says. Let me ask a question. What about Judge Wolohojian's question? What if this got sent back with the suggestion that somebody take a look at 60B6? Have you taken a look at that? Would that be an avenue for the same potential relief that the judge awarded here?
I mean, I think 60B6 allows for any other reason justifying relief from the operation of the judgment. I mean, I think that just putting that before the court and marking it for a hearing would present the same exact result as the lower court did already, which was just to apply the formula that is in the separation agreement that was the intended formula to use in the judgment. And then when you apply that formula, you get the same exact outcome.
I have this vague memory, counsel, that Rule 60B6 has some limits on it. And that's why I was asking the question, because I confess to not having done research about that. I know it's not limited in time like 1, 2, and 3 are, but I think it has limits, and which is, they're escaping me as I sit here.
So I would like to just go back to the standard of review, Your Honor, and discuss, the standard of review is an abuse of discretion. And
right, but abuse of discretion includes an error of law, and don't these cases address it as a question of law, whether this is a clerical error or a substantive error, at least in part, that there's some legal standard?
Well, I think it goes to what the judge's intent was at the time it was entered, and also how when the judge, because there's 2 prongs to this, right? There's the whether or not the corrected judgment reflects the court's intent at the time it was entered, and whether the amendment corrects a clerical error rather than a substantive error. And this gets to what her intent was. And when she went back to, a lot of deference is given to the trial court in this regard. And when she went back to consider what she did in issuing that modification judgment, she realized there was a mathematical error, and she entered the order to amend. And so I think a lot of deference is given to her, and there's a lot of case law on this in terms of the DeLuca case, the Gagnon case, the Fritzman case, the Chapman case. It all gets to the great deference that's granted to the judge's recollection of her own contemporaneous intent in framing that judgment.
Okay, and that makes some sense, right? That if you're asking what the judge intended, you're going to defer to the judge's statement of their own intent. But we don't have that here. We have her statement that she incorrectly applied 37% to the first 200,000, yada, yada, yada.
Yeah.
Is that a statement that it was a clerical error or a mathematical computation error? Doesn't seem to be to me. She's describing how she did it and then saying, I was mistaken in doing it that way.
I think it was a I think that the order to amend is a mathematical error, and it's settled, you know, and I think the language speaks to, I calculated it wrong. And it's well settled that mathematical errors are considered clerical errors that can be amended at any time. And this is the Franchi case, the Franchi management case, where under his own initiative, it sua sponte corrected a math error. And I think in the same situation as here, where she took a look at it and then recalculated and realized that there was a mathematical error. And you know, it's unclear. Did she not go to there literally is an illustration underneath the chart, you know, of spelling out what the formula is. And the parties had an agreed upon formula.
It's hardly crystal clear. I mean, if you read it carefully, then you will come away with the conclusion that you apply the percentage across the entire amount, based on the examples. Your view is nobody could have made the mistake that the judge made?
I read the illustration as being clear, as an example of what do you do when you have this amount, you apply X. What do you do when this amount, you apply Y. And when you do that, it is clear. And I think I don't know, you know, I can't speak to her, but when she went back and looked at it again, she realized that she miscalculated. And I think given the standard of review in this case, which, you know, it doesn't seem arbitrary, you know, it doesn't seem capricious, it doesn't seem whimsical. Like, these are all things that a reviewing court looks at when looking at an abuse of discretion standard, and none of that things apply. It truly looks like a mathematical error that she's corrected when it was brought to her attention. And she's allowed to do that. You know, the Rule 60A speaks plainly to the ability for a court to correct on its own initiative.
It also uses the word oversight, and I'm a little, no case law really tries to distinguish the language of the rule, clerical error versus oversight, which appear to be two different ways or reasons that you can invoke 60A. Have you seen any cases that talk about what an oversight could be?
No, I have not. I haven't been looking specifically for that word, Your Honor. I was looking more in the words of well, oversight was used specific. I should say it was used specifically if you look at the comments in Rule 60A, and the reporter's notes in rules in Mass Rules of Civil Procedure, which the domestic rules are based upon. And when you look, does Your Honor have it right in front of him? Because I can read it.
Well, I think I have the federal rules in front of me. Are you telling me the Mass comments are different?
I don't do a lot of federal practice, but I have the Mass rules right in front of me, Your Honor. I can read them if you'd like.
Yes.
So the reporter's notes state that 60A is
from which year?
Oh, 1973.
Yep, got it.
And it's the third paragraph down. Rule 60A is limited to the correction of purely clerical errors. Errors within the purview of Rule 60A include, quote, precision.
Okay, I got it. I can. You don't have to read it. You don't have to read it. I've got it. Unless there's a particular provision you want to point out.
Yep. And so I just wanted to point out that the word oversights is used there, and it does cite to a federal rule, federal case.
Wow. Okay. Thank you.
You're welcome, Your Honor. And then are there any further questions on the issue of the amended judgment? Because if not, I'll move on to the contempt, Your Honors. So the contempt standard of review also is an abuse of discretion standard, and the contempt requires the plaintiff, in this case it's the wife, to prove and the judge to find by clear and convincing evidence of disobedience to a clear and unequivocal command. And here the trial judge made clear in her judgment on contempt that this disobedience was, quote, as a result of the reasonable dispute resulting from this court's error, including father's 2017 payments as set forth in the separate order to amend. Given that wife concedes at this point that if the modification judgment as amended stands, then the husband would not be in contempt of court, and also that the contempt judgment must be affirmed as well. And so given the trial judge's discretion to amend the judgment of modification, this court, urging this court to affirm both the underlying judgment, the modification judgment as amended, and also the dismissal of the complaint for contempt. And I think if there's just about covers everything, and if the court has no further questions, then I'd rest on my brief.
Let me check. I don't see any. Thank you. Thank you both. It's an interesting case. We've been helped tremendously by your able arguments.
All right, we are live and recording.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this way, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. I'll now call the case of George Demaris versus the town of Foxborough, case number 2019 P 1780, and Attorney Trombetta, we're ready whenever you are.
Thank you, Your Honor. Your Honor, it's undisputed that the town of Foxborough terminated Officer Demaris only because he had reached the first day of turning age 66. Such a discharge, however, is unwarranted. Massachusetts General Laws 32, Section 1 does not authorize the termination of reserve police officers at performing paid details beyond age 65.
Attorney Trombetta, how is your client not a uniformed officer under the Foxborough's rules?
Well, because there's two sets of officers. There's the guys that do it all, okay? And then there's the reserve guys, which my guy is part of, which does just a subset of those. Now, I know in the past, my guy has done certain things that, you know, it was within his realm. But now, because he's in this new thing, he knows that that's it, you know, he can only do certain things.
But is the new thing working only as a detail officer with no other responsibilities or abilities? Is that what you're talking about when you say the new thing?
Yeah. And the
is there such a new thing under Foxborough's rules? Is there such a detail only position?
Well, Your Honor, I would say yes. And the reason I say yes is because if you look at the whole list, okay, there is something in there that says construction details. And that's what I think that my guys should look at, okay? And my guy should be shown, and I think my guy is probably the
That's
only
one of the things that he can do. He can do construction details. But the assignments come from his superiors in the department, right?
No, Your Honor. He only gets, see, they have to have two people. They have to have someone from the
It's a quasi-military organization. What he's being asked to do comes from a superior. He doesn't get to decide.
No, he does.
And
He
I don't
does.
understand that, counsel. I understand that he can decline to take a job.
That's
But-
right.
But that's practice, right? That's not what the rules of the Foxborough Police Department say.
Well,
The
I
rules
think,
of Foxborough Police Department say, here are all the things that you can do.
that's
and-
right.
Okay.
That's right. But what I'm saying is, once you get to age 66, okay, then you have to have some type of a cut down in your hours. And what they're saying is, you know, and I have the
Where
one
does
opinion.
that come from? Hold on. Let me just focus on that last phrase. When you reach age 66, there has to be some kind of cut down in your hours. What are you relying on?
I'm relying on the hours that are dedicated to traffic. And the only reason there would be dedication to traffic is if all the first.
Is there a document, counsel? Is there a document somewhere about the process of the Foxborough Police Department with respect to reserve officers that says anything about cutting down hours at age 66?
Well, no, Your Honor, but see, what happens is, you know, if we go back and we look at that opinion from PRAC, okay, and it says, okay, you're retired. That's who they're dealing with, and they're saying, well, because you're retired, you can come back as a reserve officer, and that's what they're doing.
To do details.
To do well, yeah, to do details.
I mean, that the entire opinion is written around someone who is proposed just to do details, correct?
Right, and details.
And I'm not sure I should call it an opinion. Letter.
Right.
Okay.
Where do we find a definition of detail?
Well, I'd have to look at that opinion, or whatever you want to call it.
Can we start by looking at the Foxborough policy document that was in the summary judgment record? I have it on page 37 of volume 1 of the appendix.
Okay, hold on. Okay, I think I have it.
Okay, so I'm looking at limits of authority, the limits of authority section.
Yes.
That says reserve officers may work outside details.
That's right.
As assigned by the chief of police. Is the term outside details defined anywhere?
I'm sorry, outside of.
Is the phrase outside details defined anywhere?
I'm not sure I really understand, but I think.
Is there a distinction? And if so, does the record show us that there's a distinction between outside details and details?
Yes, if you look at that that paper that has the what do you call it? The detail, just saying, hey, you can only do a detail, you know, which I think means traffic.
Which paper are you talking about?
It's the one cited in here. There's one on page 11 of my brief, highlighted traffic direction at construction sites. And
that's the same page as this, record appendix 37?
to tell you the truth, Your Honor,
Why don't you pull up page 37 in the record appendix, volume 1?
Okay, just give me a second, please.
This is the policy, the reserve officer policy.
You're probably going to be mad at me, Your Honor, but mine says 57.
Oh, whichever page you have, it doesn't matter. Whichever page you have, I'm looking at the reserve officer policy.
Okay.
Okay, do you have that? That's the document that's dated September 10th, 2000, but says that it went into effect on March 3rd, 2003.
I don't have it, at least, well, I probably have it in front of me, but
Okay, that's great. That's enough, as long as you have it. So there's a first paragraph that just says background.
okay,
Then there's a second paragraph that says policy. And
okay,
then there's a section within that policy that says limits of authority, reserve officers. Do you see that section?
yes.
All right, the first sentence of that says reserve officers may work outside details as assigned by the chief of police. I take it you're telling me there's no definition of the phrase outside details?
Well, I think outside details
I'm
mean,
asking for your opinion. I'm sorry to interrupt you, but
oh,
your time is limited, so it's helpful if you try to answer my questions. I'm asking you if there is a definition of outside detail.
and I would say yes.
Where is it? Where will I find it?
Well, if you just look at the observations of the people, then it's outside. I mean, I don't know. I mean, you're asking me to go one more step, and what I'm saying is that,
I'm asking you to point me to something in the record.
well,
Will we find a definition of the phrase outside details? I'm going to just assume that the answer to that is no. How, therefore, do we know whether or not your client was assigned only to outside details or to something else?
well, you see, Your Honor, he can only be assigned after age 66 to traffic detail. That's it. He couldn't do anything else.
Where do we
So-
see that in the record?
I'm sorry?
What page will we see that in the record?
It's in the page where I just read.
That in the policy?
No, it's a listing.
Okay, on the first page of the policy?
I don't know, but it says the town's position as to similar responsibilities always lacks merit because the Foxborough Reserve Office's policy states it goes down, and then 3 is traffic direction at construction sites.
So
If you're gonna,
if you look at the policy,
Yes,
if you still have that in front of you,
yes,
it's that list is preceded by a sentence that says, the following are examples of duties that reserve officers may be assigned to. And then it lists 7 of them.
well, Your Honor, the whole thing is there has to be a meeting of the minds. Now, if they've been told they can only do the traffic direction at construction sites, then their police, they know, okay? And
counsel, one of the difficulties I've had, you've been asked the same question by myself and by Justice Wolohojian, and maybe even by Justice Hand, to the effect of where do you get this from that after age 66, that the assignments have to be different, and you are pointing us to the policy, and that's astonishing to me because the very last paragraph of the policy says the maximum service age for reserve police officers shall be 65. You can't rely on the policy as giving this rule that you're coming up with. It says the opposite.
well, Your Honor, what I'm trying to say is that I think that you can't write something, like I can't write something down saying, oh, this is this, if it's wrong. And if it is wrong, then you have to fix it, okay? And, you know, what we're
That's
saying
a different
is,
argument,
it's
though.
not.
That's a different argument than saying to us, my argument is that the Foxborough Police Department was required at age 66 to alter the way in which they provided, in which they used my client for work. That's the argument I've heard you make more than once. And people have asked you each time, where do you get that from?
And I keep trying to tell you, Your Honor, there are two people that have to make it. You know, first of all, for the head of the police department and the worker, you know, the worker has to know that, hey, you know, I can only go so far. And he goes, this is the limit of what I can do. And he has to be told that.
I think we understand your argument. I think something went wrong with the clock, that your time actually expired a little while ago. So I'm going to ask the clerk to straighten that out. And I believe your argument is over. We have your brief and we have your argument. I want to check to see if there are any further questions though. All right, then we'll hear from your brother. If you don't mind, Attorney Trombetta, putting yourself on mute, then we will hear from Attorney Lewison.
Good afternoon, Your Honors. May it please the court, on behalf of the town of Foxborough, if I may I'll just address the issue of whether or not there is a definition of outside paid details in the record. And if there is a policy which defines that, I don't believe it's in the record, other than if I may direct Your Honor's attention to pages 78 and 79 of the record appendix, in which, and I believe that's a deposition testimony. It talks about Mr. Demaris testifying that the details at Gillette Stadium, which is an outside paid detail, are distinct from his regular town details. I can tell you what the policy is, but I don't believe.
We need to rely on what's in the record. There's no town policy. I mean, I'll tell you, one of the things that there are many things that concern me about this case, and I have a lot of questions for you, but one of them is that the record is not very good on summary judgment. And there are not very many, we have only this single policy. It has undefined terms. We don't have a greater list of policies from the town. I'm wondering, for example, whether the phrase detail or outside detail is defined elsewhere in the town's policy. We can't fix these things on appeal, but it's a question. I didn't see a definition for it. But it might be pertinent because you town argues forcefully that the way detail is used in the PRAC decision, letter decision, does not mean the same kind of detail that the town is talking about. And I don't know what evidentiary basis there is for that argument, because I see no definition of detail with respect to the Foxborough policy, and I see no definition of detail in the PRAC opinion. Can you help me with that?
Well, there is no definition in the record necessarily, but I don't know that necessarily that's the issue.
Well, but you argue that the type of detail that the PRAC that was involved in the situation in the PRAC letter was a different type of detail. And frankly, when I read that letter, I see that that scenario involved a former full-time police officer. So presumably someone with all police authority who then retired and did details.
Correct.
It doesn't say outside or inside, I don't know, it just says detail. And your argument is that that kind of detail is different and more limited than the kinds of details that Foxborough asks its reserve officers to do. And I'm trying to figure out what the evidentiary basis is for that argument.
But if I may just clarify, if I wasn't clear in the brief, that my argument is not about whether or not the plaintiff or the appellant was a retiree performing an outside detail. but it is the plaintiff or the appellant is a member of the reserve, he's a reserve uniformed police officer of the town of Foxborough, which is a different issue. And he is a reserve officer. This wasn't an issue of simply a retiree performing details, whether it can be defined or not. He is a reserve officer who essentially is empowered to perform almost all of the essential duties of a regular police officer.
So as a reserve officer, but you would agree that Chapter 151B applies to the town. So it's required to comply with Chapter 151B, Section 4.
Correct.
So it could not impose a retirement age restriction unless that conforms with Chapter 151B, Section 4. And I want to make sure I understand your argument as to which law overrides the Chapter 151B prohibition against age discrimination. I understand you to be saying that it is the definition contained in Chapter 32, Section 1 for maximum age for purposes of the state retirement pension plan. Am I correct?
It is Chapter 32, and in that definition section is where and only where it discusses the maximum age for police officers.
Okay, so let's look at that. It doesn't say reserve officers, but that may not be dispositive, but can we look at that definition, please?
Yes.
All right. So, I mean, I'll begin by saying that I read this, I tried to read all the pertinent provisions of Chapter 32. We agree that Chapter 32 has to do with qualification for the pension plan, right?
Well, Your Honor, my concern is that although the maximum age for police officers is contained in the statute that discusses the retirement plan, this issue is not about it's not a retirement issue. And it doesn't apply only to officers who are in a retirement plan. Why it's only there, I'm not sure. But that is the statute that's always been relied on by the courts as far as the maximum age.
Maximum age for what? Is it a mandatory retirement age? Do you have a case that says that the definition of maximum age for the pension, for purposes of the pension, is a mandatory retirement age? I think that would be very helpful. I'll just tell you that the maximum age is 65 under the pension, but I don't have to retire at 65. I can continue working till 70. There is a statute that contains a mandatory retirement age for judges. Is there a statute that contains a mandatory retirement age for police officers?
It's Chapter 32, Section 1 about uniformed police officers.
And do we have a case that says that definition acts as a mandatory retirement age?
McCarthy versus Suffolk County, which I've cited in my brief, which talks about, and if I may just, when we're talking about that issue, and I don't think the issue applies that it's a mandatory retirement age only for police officers who may be in the retirement system, and it doesn't apply to officers who are not in the retirement system. In this particular plaintiff, he was not in the retirement system. But McCarthy says that being a member of a retirement system guarantees a pension, but it does not guarantee continued employment. And it was under that statute, which this court relied on to uphold the mandatory retirement age for police officers.
All right. I'll tell you, when I look at the definition of member, which is the very next definition in Section 1, it says any employee included in the state employees retirement system. So that seems to undercut your argument just as a matter of statutory interpretation.
I understand. I do. Yes, Your Honor. I know that I've been struggling with that issue, but that is the only statute which
Can I ask counsel, so the definition of maximum age states that, I'm going to quote, that age is a bona fide occupational qualification.
Yes.
The last day of the month that a member in any such occupation or position classification attains age 65, a uniform member of the police department. So I take your point that this is not just talking about the age at which you are entitled to retirement, because it's using the term bona fide occupational qualification, which addresses something different, it seems to me. It addresses the ability, bona fide occupational qualification is, as I understand it, the language that has traditionally been used to define when age can be used to terminate employment. Is that your point? It may be in the wrong place, but that's what it's saying. And do you have anything that's construed it that way?
Again, I think it's the McCarthy case, which is the only one that describes the difference between a member of a retirement system and the issue. And in the summary judgment decision, it talked about, it was about the qualification, it was about the duties. It was not about whether or not an officer is a member of a retirement system.
Well, can I ask, this is a friendly amendment to Justice Englander's question. In the section that talks about someone who has the, it's a bona fide, I forget the
Bona fide occupational qualification.
It says that it's for which the personnel administrator has determined pursuant to section 2 of chapter 415 of the Acts of 1987. Has that occurred? Because I don't see that in the record. In other words, has the personnel administrator determined that a reserve officer in the Foxborough police department, having the duties that are enumerated in the police department's policy, it is that age is a bona fide occupational qualification for that?
Specifically for the Foxborough Police Department, no.
Okay, then how do we get to where you want us to go?
Has that determination been made for a police officer operating in a town in the Commonwealth of Massachusetts?
Not to my knowledge, other than in that Peric letter where it talks about a uniform.
No. Has age 65 been determined to be a bona fide occupational qualification for a police officer operating in a town in Massachusetts? That was my understanding of where this is coming from. That, well, maybe it's just the legislature.
No, but I think we can't, I mean, I don't want to crosstalk here, but we need to, I don't think Foxborough is claiming that the plaintiff was a police officer. At any time, you're claiming he was a reserve officer under your reserve officer policy, and that policy has the duties of a police officer, correct?
Well, I would suggest that he is a police officer. He's just in a different category, that these reserve officers have almost all of the full duties of a police officer, but they are used to supplement the regular force when they need them. They can't afford to have 50 police officers. They can only afford 20, but if something comes up, they can call on these people who perform all of the duties. So we look at the duties rather than their status.
So, but he was never employed as a police officer, a member of the police force.
No, I believe he's a retired corrections officer, Your Honor.
So, so with that understanding of what he was, has the personnel administrator determined pursuant to section 2 of chapter 415 of the Acts of 1987 that a person serving in this capacity that's age 65 is a bona fide occupational qualification?
No, but they haven't said it wasn't.
Okay, but then taking all of what we've said so far into account, how were you entitled to summary judgment on the question of, as a matter of law, that this definition contained in the retirement pension statute sets a retirement age that overrides the anti-age discrimination provision of Chapter 151B, Section 4.
Because he's a uniformed member of a police department. Because that's what he is.
But I'd like you to point to me, because as I understand it, that language does not stand alone, uniformed member of police department. It needs to be that a uniformed member of a police department that someone has, not just someone, but a personnel administrator has determined age is a bona fide occupational requirement.
Well, if I could just address the letter, the January 6, 2011 letter that the appellant has relied on. And it says in that letter from the administrator that the law required the personnel administrator to conduct a study to determine if age was to remain a bona fide occupational qualification for certain occupations identified in the law. The personnel administrator conducted the study and found that age was to continue to be a bona fide occupational qualifications for those occupations listed in the statute. And whether or not he's a reserve officer or whether he's a full-time officer, he's still a uniformed police officer performing the duties.
What were you just reading from? I'm sorry, counsel.
Your Honor, that's that PEREC letter that's in the record that where they discuss that a retiree can perform private details. That's the one for
private details. It says paid details.
Hey, well, that's just another expression. Yeah.
Also, I mean, isn't that consistent with the definition of member? In other words, the PRAC's letter entirely consistent with the definition of
member of a police department or member of a retirement system?
Member of the police department. The word member is defined. If you are relying on this statute, then it seems to me you don't get to pick and choose which definitions to use.
No, I think I thought I was clear. I hope that he is a member of a uniformed police. He is a uniformed member of a police department.
Your argument is that member means two different things in essentially succeeding paragraphs of the same section of the statutes. You say the word member as defined is defined to mean a member of the retirement system, but when the word member of the police department is used in the section, in the prior section, it means something else. I read that in your brief. Right?
Yes. And I don't know how to justify why it's like that and why the mandatory law.
Except that just above that, you have a reference to bona fide occupational qualification, which arguably is out of place in the entire section.
Well, that's the way the personnel administrator determined that this requirement was a bona fide occupational qualification, which in that Murgia, the Massachusetts case by the US Supreme Court, they found it to be rationally related for age. So
I'm not debating that. This traces back to, if you look at section 4, 151B section 4, you will see that for private individuals, a bona fide occupational qualifications is explicitly written in as a defense to an age discrimination case. But it is not written in for public employees. Instead, for public employees, the standard is something that's established by I think HRD. I don't have it directly in front of me. And so then the question is, did HRD set this as a bona fide occupational qualification, or are they equated in some way? And I think, the questions that Justice Wolohojian is asking you, and that you're obviously aware of, relate to that issue.
I want to ask one more question. I realize your time has expired, but in section 3 of chapter 32, in both of your briefs, you seem to accept that PRAC has the primary, or at least initial, authority to determine who has membership. Who falls within these various provisions of chapter 32. And I see that reflected in section 3. And section 3 has a jurisdictional provision that that says, in all cases involving part-time, provisional, temporary, provisional, seasonal, or intermittent employment or service of any employee in any governmental unit, including such employment or service of any state official, the board shall have and exercise full jurisdiction to determine such employees' eligibility for membership. And I'm wondering whether, first of all, I take it no one took the question of whether Mr. Demaris was a member in the definition of maximum age to the board, so I take it as PRAC first, and whether we're not confronting here a question of administrative exhaustion. Can you help me with that?
I don't know what PERREC would have to do with this particular issue under those circumstances. He's not in the...
Somebody has primary authority to determine what this statute means. I'm wondering if it's us in the first instance, without any input from the administrative agency that's been charged with the interpretation.
Well, I think PERREC could, if you ask them to give an opinion, they would, like in that particular letter, but there's no requirement to go to PERREC first.
Well, isn't it the case that PERREC's jurisdiction, and now I'm, what's the right word? I'm throwing out something, and it's not fully thought through, but this is sort of my sense. PRAC's jurisdiction has to do with the retirement system and who's eligible in the retirement system. And it seems to me the question being asked here is different than that. It seems to me the question asked here is whether or not 65 is the mandatory age by which someone can be terminated, which might be an HRD decision, not a PRAC decision.
Well,
thoughts on that?
Were you asking?
Yeah, well, you're still up, counsel.
Well, we just look at the statute. I don't know that there's a requirement that we have to go to these various agencies, particularly when I'm not sure HRD would take jurisdiction over a town matter.
Well, but HRD, isn't HRD the agency that's mentioned in 151B section 4(1)(c)? I don't have it in front of me. Anyway, we can look that up. We can look that up.
All right, I think we're going to have to leave it there unless I see any other questions. Thank you both. It's an extremely interesting case. We've been helped by your arguments and the
All right, we are live and recording.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this format, all the ordinary rules of oral argument apply, including that each side receives 15 minutes to argue with no rebuttal. I'm now going to call the case of Mark R. Jubert versus Todd Miley, case number 2020P 0506. And Attorney Jubert, I hope I've pronounced your name correctly.
You did.
We're ready whenever you are.
Okay. May it please the court, I'd like to begin by providing a very brief history of the parties and transition to the four issues I've also covered in my brief. First, the parties met each other while working at UPS in 1980 The appellee negotiated contracts with the Teamsters organization at the national level and was a business agent. And at United Parcel Service, where I was also employed. At this time, the appellant was unskilled laborer with a high school education. He continued to work for United Parcel Service for the next 15 years until sustaining a work-related injury. After leaving the employment at UPS, the appellant attended college, earning a bachelor's degree in science and biology, a master's degree in biology, and then a law degree. In the years after leaving United Parcel Service, the appellant and the appellee kept in contact off and on. In the summer of 2010, the appellant was going through a divorce, and the appellee offered appellant an apartment that he had at no cost because of their long-standing friendship. Within a month of appellant moving into the appellee's building, the fall of 2010, the appellee asked appellant for assistance to obtain a deposit that he had made at an auction. The appellant drafted a letter and mailed it to the auction company. The deposit was returned to appellee almost immediately, and no further action was taken. There was no other legal representation appellant provided to the appellee throughout the time the parties knew one another. And when the appellee was asked at trial and at his deposition what legal services or acts appellant provided, the appellee could not answer with a single act or service.
So I need to, or maybe I'll call you Mr. Jubert, although I know that you are a lawyer as well. You just made a statement there were no other times when you acted, or Mr. Jubert, I'll say you, acted as a lawyer for Mr. Miley. But didn't the judge make specific findings to the contrary? And isn't that where we are? Okay.
Exactly.
So if you say, I didn't act as a lawyer, it seems to me that you have to give us a reason to find that her findings were clear error. She found that you acted as a lawyer for Mr. Miley, specifically with respect to setting up the corporation and with respect to the shares of that corporation, and with respect to bringing the property that he owned as an asset of the corporation. What do you say to that?
I could take them one by one. In 2011, Mr. Miley asked me if I would, well, actually it was prior to that. He introduced me to a property that he owned in Leicester, Massachusetts. He asked me if I would, he knew that I was not really active in the legal profession. I did some patent law. I did a few workers' comp cases and some real estate transactions, but I really was leaning heavily to go back towards doing a career in the biological fields, more in line with what I really enjoyed more. So he introduced me to this piece of property where he wanted some help in developing it in one way or another. He introduced renewable energy and asked me if I would be interested in that. The testimony in both of our testimonies at trial speak to that a lot. He asked me also if, we actually, let me back up. We met with solar people that I had located after we determined solar was the right way, the path to go. I had met with a few solar companies and introduced them to Mr. Miley. And we had several meetings in the summer of 2011 where they discussed what they would want. And one of those things that they would want was to do business with a corporation. On the second day of the trial, one of those representatives, who was named Charles Jenkins, appeared and gave testimony. In his testimony, he said that it was he who introduced the prudent. He said the word he used was it would be prudent for Mr. Miley to form a corporation. The other partner he had was a gentleman named Mark Kyla. Mark Kyla provided an affidavit to the Board of Bar Overseers who investigated these actions from a complaint Mr. Miley placed in 2012, and their decision in a letter was 2013.
Okay, so paragraph 28 of the judge's findings. Let's get down to brass tacks for a moment. Jubert advised Miley that to develop a solar farm on the Leicester property, he should transfer the property to a corporation. Miley resisted this, but Jubert ultimately convinced him to do so.
That never happened, Your Honor. The
That's
record, there's
clear
nothing in the
error.
record.
There's no basis for the judge to have made that finding in the record.
No, there's not in the transcripts. You can go with the index and look for it. That is not anywhere in the deposition, Miley's deposition, or in the trial. In fact, the only person who spoke to that issue during the entire trial was Charles Jenkins, who was the one who claims that he presented that to Mr. Miley. I had no idea that that's how they did business. I was a novice. I was as green in this area as Mr. Miley was. I told Mr. Miley I had no idea how to do any of this. He said, we'll learn together. So we did. I didn't involve any legal work, so I was comfortable doing it. And
Well,
Mr. Jenkins
how
is the
about
one who said
29?
he
Miley
did it.
directed Jubert to prepare the documents necessary to incorporate and convey the Lester property to corporation. Let's leave
That
aside,
is true.
leave aside the first three words. Did you prepare those documents?
I worked with him to fill in some fields on the forms we found online at the Secretary of State's office. Mostly it's names, addresses. He invited me to be an officer and a director of his corporation.
In order to find, what is the test for clear error in findings? What is a legal test?
Is a clear error in finding abuse of discretion and error of law.
No, for a clear, in order for us to rule that a particular finding of the judge was clearly erroneous, what is the legal standard for?
The standard is in civil, the lower court's finding is clearly erroneous.
Yes.
And
What is the definition of clearly erroneous?
it's not factually based.
Right, there's no support for it, either direct or circumstantial in the evidence. That's the standard that we're going to be using. It's not it's not whether or not there was conflicting evidence. So so I think that might be part. Can you tell us why, when you're making these responses to Judge Englander, what I'm actually sort of hearing is that there was conflicting evidence on the point.
There was no conflicting evidence. I never brought it up. The other people that were in, and let me back up. In Mr. Miley's deposition, he was asked by Attorney Morrissey, who introduced the thought or the suggestion of forming a corporation. Mr. Miley, he said, I don't know. He said, was it Mr. Jubert? He said, I don't know. He said, was it the solar people? And he named them. He says, I don't know. All I know is it wasn't me, which is true. It was not Mr. Miley. There's no conflict in it. Mr. Charles Jenkins said it was him, and Mr. Kyler in his affidavit to the BBO said we required it. Those were what they said. They're in the record. I submitted them as exhibits.
In the end, it isn't the crux of the matter the documentation that you created that gave you an ownership interest in the corporation that was created?
I didn't create that. Mr. Miley and I discussed it. He offered it. He incentivized me, I guess. He wanted to work together. We never talked about sharing profits. We only said, this is what, I'm going to help you and you're going to help me. And
I read his testimony yesterday, and I'm sorry that I'm not going to be facile enough to pull it up. But I'm pretty sure that he said you presented him with the documents, which in combination transferred the property to the corporation and gave you a 50% share in the corporation. Didn't he testify to that?
He testified that he didn't know what he was signing. Attorney Walker, who represented me at the trial, walked in through every line.
The question I asked comes before that. Didn't you present him with those documents?
No, I did not present
Where
him
did
with
they
those
come
documents.
from?
We sat at a computer at his girlfriend's bakery and filled it in together. I presented nothing.
Are you telling
me?
me?
For him.
Well,
he took those documents home, he said in his deposition, and mailed them at some other point.
Counsel, if we're both talking at the same time, it's not going to aid your case because I'm not hearing what you're saying. Did
I'm
he
sorry.
testify that you presented the documents to him?
He testified both in the negative and in the affirmative on that issue.
In other words, he said
He said-
something
he
different in
did
his
say that.
deposition than he did at trial?
Yes.
Was
we-
he cross-examined at trial on that point?
Extensively, the documents were, Attorney Walker went for many pages on that point. Mr. Miley had a hard time remembering a lot of it. And I think through the question and answers that he and Mr. Walker had, he was able to recall pretty much every line of everything he wrote. I did not write these by myself and present them to him. That is in my testimony, or it wasn't Mr. Miley's ultimately, but it was what he said at one point.
Thank you.
Oh, do you want me to pick up where I left off? I think I was talking about the attorney-client relationship.
You can continue wherever you think fit.
Thank you, Your Honor. The record, well, Judge Friesen in my appeal said Judge Friesen abused her discretion and made errors of law when she established an attorney-client relationship existed between the parties. The record shows that the appellee could not identify a single instance where appellant provided a legal opinion or provided a single service for appellee as an appellee's attorney relating to the period of time of the joint venture. Appellee on cross-examination admitted that the only evidence he had to justify his subjective belief that appellant was his attorney was that the appellant was receiving his mail at appellee's building. In fact, both in trial and his deposition, the appellee acknowledged that the responsibilities of the appellant was to conduct scientific-based research from magazines and articles he provided, and then to give a general understanding of what I had read back to him about the different types of renewable energy, including wind turbines as well as solar projects. I believe that the Judge Friesen made a mistake by not applying and being consistent with Davo versus American Home Assurance Company. According to this, Massachusetts courts recognize an implied relationship when a person seeks advice or assistance from an attorney. It's true that I was an attorney. At some point during that time, I was also suspended and was not acting as an attorney at all. Number two is the advice or assistance sought pertains to matters within the attorney's professional competence. I never claimed to be a corporate attorney. I was a patent attorney. I told this to Mr. Miley many times, but he didn't ask me to be his attorney. He asked my help in developing a solar field ultimately.
Although Mr. Miley did testify at one point anyway, that he did ask you to be his attorney for the solar project, correct?
No, he never said that. He never, I don't know that. No. He may have said that in his testimony, but he never, Attorney Walker, and he was asked, what actually did you ask Mr. Jubert to do? In fact, in the deposition, he was also asked by Attorney Morrissey, what specifically did you ask Mr. Jubert to do that was of a legal nature? And he would just, on occasion, would just say, oh, he was my attorney. But there was no other actions or opinions. You were going to ask a question, Your Honor.
I was, and I didn't mean to interrupt you. Did you have a chance to finish that answer?
I think so.
Okay. Could I, just because your time is short, could I change gears just for a minute and ask a question about your challenge to the attorney's fees? Is your challenge to the fees based just as to the timing of the fees?
No, there's the procedural issues, and there's also the fact that the damages were never argued in the of any of the counterclaims throughout the entire trial. Judge Friesen even noted that, and she put a footnote in her judgment saying that, well, did you want to ask a question? I'm looking at, did I? Well, anyway, I thought you were about to ask a question. I apologize. So anyway, the attorney's fees, and there's the due process argument that I brought in the transcripts also of that motion for attorney's fees and costs. I never had a chance to do any discovery or review an attorney-client agreement to see if the rates match that. I was not given anything on that would help me find if this was an accurate invoicing.
Could I ask another similar question? Were there findings and proposed findings and rulings that the parties submitted? There was no closing argument, if my memory is correct, on either
That's
side,
true.
but there were proposed findings and rulings. Are those included in our record?
I don't know if I included them or not at this point, Your Honor. There was no closing arguments. I read that yesterday, but there was definitely findings of some finding of fact submitted, proposed.
Thank you.
Let me check to see if there are any further questions, Mr. Jubert. No, seeing none, we'll hear now from Attorney Angelini. Thank you.
Good afternoon, Your Honors, and thank you. I need to remind the court, as has been pointed out, that this is a challenge largely based on the claim that there is no evidence in this case to support the judge's findings. I assure the court, and do it respectfully, that the record in this case includes Mr. Miley's testimony that Mr. Jubert acted as his attorney. In at least one occasion, that has been acknowledged by Mr. Jubert. There is testimony in this case that Mr. Jubert was introduced to Mr. Miley and his friends and colleagues as Mr. Miley's attorney, that he was known as Mr. Miley's attorney. There is evidence in this case that Mr. Miley asked Mr. Jubert to be his attorney with respect to this solar farm. There is evidence in this case that when Mr. Jubert made a mistake with regard to the language in the deed and filed what he acknowledged as a scrivener's error document, he identified himself with respect to that deed as an attorney, that he was acting as an attorney. There is ample evidence in this case that Mr. Jubert did a number of things of the type prepared by attorneys. He drafted bylaws, he organized a corporation, he drafted deeds, he arranged for the recording of those deeds.
He says he didn't.
I appreciate that, Your Honor, and that's why they put black robes on certain of us to make those decisions, and that's what Judge Presiding did.
Counsel, you know, one of the things that happens in that situation is that we then ask you to help us, and you know, is there a place you would point? I actually looked at the record, and he's pretty clear, your client, saying, I did nothing with respect to this document except sign it.
That's
and
correct.
He kind of says that over and over again.
That's correct.
And I get. Can I shift to another topic unless my colleagues have a question? What is your best argument for why you're entitled to attorney's fees in this case?
You know, I was concerned that you would ask me that question, Your Honor. So I'm actually prepared for it. My best argument is that the payment of attorney's fees or the award of attorney's fees was not appealed, except in one respect, and that is with respect to an alleged violation of rules which are inapplicable to this case.
Are you saying that, I mean, he's appealed the judgment, right?
But the issues on appeal there's no designation of the issues. If the issues raised on appeal that the judge committed error by awarding legal fees.
And attorney, what is the legal authority for the proposition that attorney's fees can be awarded as part of the damages on I think this was on a fraud claim, correct?
Yeah. Well, as much as I was concerned that Judge Englander might ask me that question, I was concerned that you would follow up with another question, Your Honor. I'm not going to be anything but frank with this court. And I respect your right to ask me this question. I think it's a problematic situation. But on the other hand, I do not think that issue was properly appealed by Mr. Jubert.
Well, if he takes an appeal from the judgment, so you're going to have to help me here, counsel, again, twice now in the first 4 minutes.
I'll do the best I can.
If he takes an appeal from the judgment, what does he have to do to perfect an argument that says there was no basis for the award of damages?
I think he has to identify issues in appeal. That's the process of an appellate. I mean, we clearly are required to do that by the various rules. So if you look at, he's raised 5 issues on appeal. The first, that there was an abuse of discretion in regard to that Mr. Miley didn't have significant enough mental capacity, and therefore, I guess everything he said should be disregarded. The second is there was an error in concluding there's an attorney-client relationship. The third is that there was an abuse of discretion in determining there was a fraud or misrepresentation. The fourth was that there was an error because the judge allowed the defendant's motion to be heard after expiration of the time standards for post-trial matters. And the last was that it was error for the judge not to give Mr. Jubert a hearing when he asked her to vacate the judgment by a Rule 60B motion. Those are the issues in appeal.
So I take it what you're arguing is not that you're not contending that the appeal is from the judgment, that the judgment is before us. But you're arguing essentially appellate waiver, that he hasn't made the argument on appeal.
That says it more articulately than I did, Your Honor, but I am.
But he did make the argument in his brief. So your argument is even more refined than that. It's, if he makes the argument in his brief, that's not good enough if he didn't raise it among the issues that he's presented.
Your Honor will note that I did not address that issue in my papers. It was not accidental. I did not think it was properly raised. Look, I understand the court's point. And let me just say, I considered the judge's ruling to be unusual in that regard, but I think it imposed certain burdens on Mr. Jubert, which he did not observe.
Can I ask Mr. Angelini a question that may be related, and maybe you've answered it and I just overlooked the answer as part of what you were talking about just now. But with respect to damages on the counterclaims, what's the evidence of damages on the counter, other than money had and received, which was addressed? But as for the other claims,
well, I think the only damages awarded in this case fall into two categories. One is the money had and received,
right?
The so-called attorney loan, the designated attorney loan, and the other was the legal fees. I think that comprises. Could you prevail?
Sorry, I didn't mean to interrupt you. I apologize.
No need to apologize.
I guess my question then is, if there was a failure in proof of damages, was it proper for you to prevail on the counterclaims? Don't all of those counterclaims require proof of damages as an element?
Well, there was certainly proof of damages with respect to the $4,000 attorney loan.
Putting aside those other issues.
Right, and there was certainly proof submitted to the court with respect to attorney's fees. Since the question was asked, I will say that Mr. Jubert received that motion. He had the opportunity to comment on the motion, and I say respectfully, he did not properly answer the court's question as to whether he had an opportunity to contest that motion. He did, of course.
There was a point at which the evidence was closed in the case. And prior to that, there was no evidence of attorney's fees submitted.
You're driving your point home, Your Honor, and I acknowledge it. Yes.
No, I'm asking, that was actually a question.
It's true. Okay. It is true. Yeah, it's true.
So
the record's clear.
It's a little bit of a hybrid situation. It looks like the judge awarded attorney's fees as part of the damages on the subsequent claim, but then actually handled proof of the attorney's fees as though there were some kind of fee shifting statute that would allow for fees, and then their post-trial submissions on fees. Am I correct?
I think that's fairly stated, Your Honor, yes.
Okay. I mean, if this were a 93A claim, that would have all been okay. I mean, actually, there are even some 93A decisions where attorney's fees can be awarded as part of the damages on the claim, although I think factually they're a little different from this situation. Yep. But that's not what we've got here. The underlying claims are common law claims. So,
correct.
Right.
If we were to get a hold of the findings and conclusions of law, which I don't think are in the record.
They are, Your Honor.
But if we were to get a hold of yours,
oh yes,
would they make the argument that the damages on your counterclaim should include attorney's fees?
They would not. So I won't, we have argued this case in our brief. The associate who did so did a far better job than I could do so here. I don't intend to bore you with saying what you can read and have read. But I would say to you that this is an important matter. It is a small matter, but it is an important matter. There is no question that the record supports that Mr. Jubert acted as an attorney for Mr. Miley. There is no record that he imposed himself as an owner of Mr. Miley's property. And, you know, putting aside the legal error issues in this case, there are important ethical rules here at play. And it is improper for a lawyer to take a fee which is unrelated to his services. It's improper for a lawyer to represent a client in a business matter without a full disclosure and a written acknowledgement by a client waiving conflict and after having the opportunity to consult with independent counsel. As Mr. Jubert knows, I have pursued this case on behalf of Mr. Miley, who is now deceased, because I view it as an important matter for this court, an important matter for the profession. So I have no enjoyment of saying to you that Mr. Jubert has misrepresented the record in this case. I have no enjoyment in recounting what Mr. Jubert attempted to do here, but I have pursued this appeal, responded to this appeal, even though Mr. Miley is deceased, because I think it's important for you to hear this and for this matter to be adjudicated. I have nothing further to say, Your Honor, but I'll be happy to answer any question.
Let me see if there are any other questions. No, I don't see any. Thank you both for your arguments. They were helpful to us in this case, which is an interesting case, and the case is now submitted. Thank you.
Thank you, Your Honors. Have a good day.